Supplementary list, fresh admission, item number 1.
So all these three matters are covered by this, your lordship's judgment, my lord, which has been now downloaded, my lord. I just came to know recently. As WPC is 1608 of 2014.
It's already uploaded.
It's already uploaded. So here the ASO's orders are challenged. You know, the
Right.
third.
All right.
And they belong to two different mojas. Your lordship need not. First one is Shampur, the other one is Andharu.
Moja is not mentioned.
I'm sorry. So in all these three cases,
We'll just say it's covered and similar directions are used.
similar direction. Here the ASO's orders have to be quashed,
Ah.
and the land has to be settled with the petitioners, my lord.
Right.
It's WPC 1608 of 2014, my lord, and a batch.
In 1608 2014 batch. Monday's order. Second January.
Here the ASO's order have to be quashed.
The orders of the Assistant Settlement Officer challenged in these petitions is hereby quashed. And the following directions are issued, and we'll copy those directions.
And the land has to be restored, you know, to the petitioners.
All right. And consequently, the land shall stand restored to the petitioners.
Greatly obliged, my lord. All the three matters at the same.
Yeah.
Item number 2.
May I please, my lords? My lords, your lordship directed to file the exemption certificate for eligibility for IPR, my lords. My lords, I have filed the exemption certificate.
Just now I have received the copy. Your lordship, what is here, your lordship, in this case?
My
Is
lords,
that the excess amount has been taxed. Your lordship, the certificate, something has been in the certificate, but he has produced more than that certificate, that quantity in the certificate.
no.
Over and above.
No.
Over and above. And that your lordship may kindly turn to
Exemption is with regard to over and above the installed capacity.
your lordship. Your lordship, here at page 20 of the assessment order, itself says so.
My lords, I
The
have,
dealer is not eligible to get tax exemption on the excess quantity of finished product over and above the quantity shown in the PRC, your lordship.
my lords,
So
I
that
have,
is the issue. Just now,
One-
this is the copy.
one minute.
This unit is EMD. This unit is EMD.
Your lordship, no, not
My-
EMD.
my-
Original capacity, not EMD.
my lords, I have filed the exemption certificate at page 4 of the bunch I have given today. My lords, kindly.
Hmm.
3, my lords, page 3. This is last column, my lords, 6th year from 27/12/98. Your lords,
31/7/99.
98 to 31/7/99.
Hmm.
The exemption is this, my lords. I have not gone beyond this, my lords. My protection
Is within these quantities.
within this, my lords. And my lords, I have given 3 judgments, one of your lordship, my lords, where exemption certificate, the taxing authorities are bound by the exemption certificate. And this certificate was never recalled or changed, my lords. That is the issue, my lords. Question of law I have framed, your lordship. Page 8.
That's what we relied on in the prior review.
That your lordship, that is not displayed, your lordship. Your lordship has already, that bilateral, your lordship already decided.
Page 13, my lords. Page 13, my lords.
Another Nababharat, I think.
Your lordship, many judgments have been passed, your lordship.
Also passed some orders.
Only your lordship, I have to go through all these documents next week
My lords,
or tomorrow.
question
your
of
lordship.
law at page 13. Question number 1. Page 13, my lords, question number 1. Whether on the facts and circumstances of the case, Honorable Tribunal justified go beyond the eligibility certificate granted by the competent authority when the eligibility certificate is not recalled or cancelled by the competent authority.
All right. You say admit the following questions framed for consideration. Was the tribunal justified? It not going by the eligibility certificate granted by the district industry center, right? The eligibility certificate is granted by the district industry center.
My lords.
By the district industry center, which has not been recalled or cancelled by the DIC. Question mark. That's the only question, or you want the second question also?
Your lordship, second question.
All right, second question. Whether the initiation of proceedings under section 12(5) of the Central Sales Tax Act was justified in law. Question mark. Counsel, the petitioner has placed before the court an entire bunch of documents, including copies of the judgments he seeks to rely on. So a copy has been served on Mr. Sunil Mishra, learned standing counsel for the department. He needs time to examine them and make submissions. Five B CST bracket Orissa bracket. All right. List on. February. Gratefully.
Item number 3.
May I please, your lordship? My lord, in this case, department has come up with the appeal. My lord, I have filed one similar order passed in another appeal, my lord, for different years. My lord, this is for 2009-10.
All right.
This is pending for the Honorable Apex Court for that.
All right. In view of the order passed by this court on 2nd January 2023, in ITA 47 of 2020, bracket Commission of Income Tax, bracket TDS, Bhubaneswar versus Vodafone India Idea Limited, which was for assessment year 2011-12.
Yes, ma'am.
The court declines to frame the questions urged in the present appeal, which pertains to the AY 2009-10. The appeal is accordingly dismissed.
Item number 4.
May it please the lordships. Lordship may kindly turn to Annex 3, page 41, my lords. A survey was conducted in August 2008, page 61, my lords. Sorry, 41. I'm sorry, 41. Then, my lords, no incriminating materials was found during the course of the survey, and they impounded some books and etc. Then, my lords, lordship may kindly see Annexure 1 and 1A, Panchanama. In the Panchanama, lordship will find that is at page 30 to 38. Nothing has been found during the course of the
So Kabul Chawla.
My lords have delivered the judgment in Jami Nirmala. My lords have another interesting fact. Lordship will kindly see page 60, assessment order. Assessment order, page 60. They
should not have remanded to the AO, but have quashed the.
Yes, it's a wholly without jurisdiction, my lords. And your lordship's judgment, I have got the judgment in Jami Nirmala. I'll just place one paragraph, page 5. One paragraph. My lords may be pleased to see. SSC has inflated the expenses. This fact has been proved. Beg your pardon?
Where are you reading from?
My lords, page 60.
60.
Of the brief.
Oh, I see. All right. All right.
Yes. Contractors for which SSC has done the raising work, a search and seizure under section 132 of the IT Act was conducted in the case of Sirajuddin and Company. Many incriminating documents were found that the SSC used to pay this certain amount in cash to the minor at as high as 50% to 60% total receipts. The contract
for example, impounded CD. Now that CD impounded from Sirajuddin without taking recourse to 153C,
Oh,
without recording any satisfaction. I have also
but that AO.
yes,
All right.
that and page 22, my lords, is the question of law I have framed. So two questions are vital, my lords. Question 1, then my lords
3.
3. Yes, my lords. These are two.
If this is ex parte, he has never appeared before that. Whatever now Miller claiming and arguing before this annual court, he has not appeared before the assessing authority, Miller. It was
Your
ex parte.
invocation of jurisdiction under section 153 itself.
1 minute. Let him just.
Okay. Sorry.
Similar,
Your old habits die hard. So,
similar, he was passed the order ex parte. Whatever Miller argue here before this annual court, that is not permissible. Whatever the reason Miller covered by this judgment, Miller. Kindly see the Miller, the order of the tribunal, page 116, Miller. What is tribunal did, Miller? What tribunal Miller did, Miller, directed to all the raise all these will be with the for consideration, Miller.
It's not like that kind of.
not necessary.
There's no need to send it back all the way.
No,
Yes.
because
Question of law is very clear.
correct, Miller. I understand, Miller.
It's a settled position in law.
But fact remain, whatever argue before the IO,
It's
if I
a
was
waste
considered,
of time. It's a waste of time.
your lordship keeps you fix up a time that should be disposed of in that time.
No. It's going back to the AO means from AO, then CITA, then IT80.
No, because
Looking at 5 years more then.
no, because he has not appeared, Miller. He has not raised any question before the first of
This
the
is
authority,
a
Miller.
question of law. There is no question of raising it and not raising it. You say admit the following questions are framed for consideration. 1 and 3. All right. List for final hearing on March 23rd.
There's on IA, my lords. They're pressing hard. IA.
We'll just issue notice on the
It said Miller directed to for Rio. I don't think they will praise because it is directed to Rio for praise assessment. We have no demand at
Just
all.
notice
Miller.
on the
Face of it, Miller.
all right.
Notice may go, man.
Yes.
Yes.
Much obliged. Much obliged.
Item number 5.
May I please your lordship, my lord. Here, my lord, I am challenging the order by annexure 5, my lord. The Kisam of suit plot is a gochara. Now the Tahsildar has de-reserved the gochara land into Patita, my lord. My humble submission before your lordships, according to section 3 of OGLS Act, only collector has power to de-reserve it, my lord. But here the Tahsildar de-reserved the gochara land to Patita, my lord.
The last 8-9 years, it's all happened, sir. Nothing has happened after that.
My lord, but
You just left over the matter. You're not interfering at this stage. You see, this petition was filed in 2014, questioning the de-reservation of a plot in Kendrapada district by the Tahsildar, only on the ground that it should have been done by the collector and not the Tahsildar. Paragraph. Considering that there is no interim order passed by this court during the 8 years of pendency of the present petition, the court is not inclined at this stage to alter the status quo. The petition is dismissed.
Item number 6.
6, may I please your lordship, my lord. This is a PIL. My representation is annexure 1, my lord. Now the government is going to evict the small business holder, my lord, who was doing small business at the RTO office. So I made a representation before the
This
collector.
is 2019, sir. You make a fresh representation if anything is happening now.
My lord, if there is no
If
action,
any
then
fresh cause of action is arised, since the
my-
petitioner seeks leave to withdraw this petition, with liberty to file a fresh petition. If any fresh cause of action arises, dispose of is withdrawn to liberty.
obligation.
Item number 7.
Item number 7, my lord, this is PIL, my lord, representation under annexure 3 series is pending, my lord.
complete the consolidation operation, which is
My
started.
lord,
in 77.
consolidation of the operation started since 1977, has not been.
These are not the things to be dealt with by means of a representation.
Yeah.
I do not know what is the current status of the consolidation operation, but if at all it is, there might be some stay order from the Honorable High Court in
No,
different
no,
mojas. No,
nothing.
you have not disclosed it, nor you have got any knowledge about it. It is concerning the entire Tahsil. So, representation disposal will not suffice the.
It seems unlikely. 1977 onwards, for
My
40
lord, as a result of
45
which-
years, consolidation is going on. Can't be. How can it be going on for 45 years?
My lord, Annexure
Something's not
2
right.
is the RTI report. They have submitted, my lord, 77, this operation has been started till not been end, my lord. And as a result of which no ROR has been issued, only temporary ROR has been issued, and the petitioners have been suffering, my lord. So far as the caste certificate, other certificate, utility certificate, others,
Where is the RTI reply?
my lord, Annexure 2, my lord. That is in,
No, it's handwritten, sir. Can't be.
my lord, your lordship, direct the collector take a decision in this regards, my lord.
No, it's not sounding right at all.
Otherwise, the petitioners will suffer, my lords.
The officer says that Chocobon is the bonds.
That's a very strange thing. 45 years, how can consolidation be going on? You want to take instructions. It seems strange that consolidation operation will be going on for 45 years.
Or if your lordship will direct the collector to look after this issue and ensure that the.
No, but let's find out what is actually the factual. Mr. Mohanty Leonard, AGA seeks time to ascertain the factual position regarding the consolidation operation. At his request, list on 20th February.
Obliged, man.
Item number 8.
None
Might have been,
appears.
might have been infructuous second
That's
appeal
what-
stage.
None appears for the petitioner. Dismissed.
Item number 9.
None appears for the petitioner. Dismissed.
Item number 10.
May I please your lordships, in item number 10, my lords, I have very small and limited prayer, my lords. Here, the petitioner has challenged an ex parte adjudication. Annexure 2, my lords. And this, which is ex parte adjudication order under Annexure 2, which was for the first appellate authority. I challenge this order for the learned first appellate authority, raising certain contentious issues, my lords, relating to the jurisdiction and relating to the maintainability of service tax on the impugned services, my lords. My contention is that on merits also we had made a small prayer, my lords. The show cause notice in the present case was issued without supplying me the relied upon documents for which the show cause notice was issued. And the demand which has been raised in the present case, my lords, those services were relating to the period prior to 1/7/2012, based on which the service tax demand has been confirmed upon me. But with effect from 1/7/2002, with the period with which I am concerned, my lords, in the present case, my lords, the impugned services comes under the category of deemed sale, my lords, and it is a declared service with effect from 1/7/2012, as per the definition of section 66E clause F of the Finance Act, my lords. And that apart, my lords, certain new grounds have also been introduced for the first time by the learned first appellate authority so as to uphold the confirmation of demand, invoking the provisions of Rule 5A of the Finance Act, my lords, service tax rules, which is now presently subject before the Honorable Supreme Court, my lords, as held by the, this has gone against.
What has happened to your appeal?
My lords, this appeal in the meantime has been disposed of without recording my contentions, my lords, and without giving me an
Where is that
opportunity.
appellate order? Where is that appellate order?
Appellate order, my lords, your lordship should find is at annexure 9, my lords. It starts with the running page 473, my lords. And
no, but against the first appellate order, you must have a.
Yes, there is a second appeal, my lords, but the whole difficulty is that here the petitioner was set ex parte, my lords, because of the non-appearance of the counsel who was representing the petitioner before the learned adjudicating authority, my lords, and your lordships are aware, my lords, for the laches on the part of the lawyer, my lords.
No, but that anyway, the first appeal, first appeal, what happened?
My lords, in the first appeal, we had raised these contentions, my lords, but without recording the
Anyway,
submissions of
so
the
you have to
petitioner,
file
my lords.
the further second appeal.
Yes,
now.
I fully oblige. I mean, I'm grateful to your lordships because I'm conscious of this facts that your lordships, when there is an alternate remedy, your lordships should definitely not intervene into the matters below. But here, since many contentions issues had been raised before the learned first appellate authority, and the show cause notice was issued without giving me the relied upon documents below. This is a basic requirement, as your lordships are aware, as held by various judgments of the Supreme Court and so also by the board circular issued by the CBEC, my lords. In the absence of the relied upon documents, lords, and the opportunity of not filing a proper reply. In fact, there was no reply also filed to the show cause notice, and the adjudication order, the petition was also set ex parte, lords. So all these contentions were raised before the learned first appellate authority. And if I am been deprived of all this, lords, and if I go to the second appeal, lords, with these observations, lords, it will actually be detrimental on the part of the petitioner actually to prove a case, lords. And there are many contentions issues. The another issue that after enactment of the GST with effect from 1/7/2012, Chapter 5 of the Finance Act stands repealed by virtue of Section 173 read with 174. And on this particular question of law, writ petitions have already been admitted by the Jharkhand High Court, Guwahati High Court, by the Gujarat High Court, my lords, and your lordships in Delhi High Court also. In the case of mega cabs, my lords, if your lordship would kindly recollect Rule 5A. Rule 5A invoking which, yes, my lord, that is now for the Honorable Supreme Court. So these are the contentious issues, my lords. I can go back to the authority. There is no, my only prayer was to remand back the matter to the authority to have a fresh look upon this pleadings which have been raised.
No. Merit also in consider, my lord. Merit also consider.
All right. It's all right. It's all right. The petitioner seeks leave to withdraw the present petition with liberty to pursue the statutory remedy of a further appeal provided under the statute in question in accordance with law. You're still in time, I think, no, for the appeal?
Well, your lordship, kindly protect me for the limitation.
All right. If such appeal is filed not later than 27th February 2023, accompanied by an application for continuation of delay citing the pending present petition as the reason for the delay, it will be considered in accordance with law by the second appellate authority. The court clarifies it is not expressed anyway the matter.
Yeah, your lordship, just observe since these contentious issues are there, I can raise them for the
Obviously
second appellate authority because
obviously you can.
Otherwise it will be detrimental for the petitioner because in both the forums, if I am having a concurrent view, it would actually be very difficult for the appellant, I mean, to get it.
Not really. With such persuasive counsel, I don't think there will be the
deeply like. The certified copy at annexure 9, may please.
Yes, the originals be returned subject to being substituted, attested photocopies. All right.
Item number 11.
May I permitted to withdraw, my lord?
Disposed of is withdrawn. All right.
Item 12.
May I please, your lordship?
Yes.
The appellate order, the order of the learned single judge.
Yes.
Is being annexure 1, my lords, is being assailed to your lordship. The petitioners herein wanted to assert their rights under the Forest Dwellers Act, my lords.
2006.
2006. My lords, the learned single judge has committed an error of record in understanding that the Act applies only to scheduled castes and scheduled tribes. There's another category of persons, which is the other forest dwellers, which he has
traditional forest
dwellers, which he has overlooked altogether. And my lords, there are various other, but if your lordship will find kindly take the impugned order 28. Para 6, my lords. It is nowhere
the whole purpose of the 2006 Act was to deal with.
Yes, my lords. And he says the onus was on me to go and assert my rights under the Act. The scheme of the Act is that it is of the Gram Sabha to initiate the entire proceeding and to recognize the rights of the forest dwellers, my lords. There, my lords, he has proceeded on a wrong footing altogether.
Right. Yes. Mr. Monty?
My lord,
as I find a parallel comment was received from the concerned district magistrate, may I be permitted to place it in shape
All
of
right.
affidavit?
Mr. Mohanty seeks and is granted 4 weeks time to place on record an affidavit indicating the stand of the state government. Rejoinder that to be filed before the next date. Interim order to continue. List on 11th May.
Item note 13.
Your Lordship, item number 13 has become infructuous.
Disposed of.
Item note 14.
Your Lordship, infructuous.
Disposed of is infructuous.
Item note 15.
I put down this I. For recall.
It has been dismissed for non-appearance. Again, your Lordship recalling,
He's not appearing in this also.
your Lordship.
And we pass over once.
Yep.
Item note 16.
None appears for the appellant. Discussed.
Item 17.
May I please, your Lordship. Your Lordship may not record my concession. Your Lordship, the Lorraine Tribunal's order at page 35.
Yes.
Your Lordship, the Lorraine Tribunal has observed a levy of penalty under section 9C5. But in this case, the assessment has been done under section 10(1) and the penalty has been levied under section 10(2), your Lordship. And under section 10(2) penalty, your Lordship is very much clear.
Correct.
Here, your Lordship, the issue is that interpretation of the statute, whether chips and sand will coming under the purview of mineral or
So
not.
that's bona fide.
Your Lordship.
All right. You see the present revision petition by the department arises from an order dated
Question of law is at page 18.
Yeah, 30th November 2019, passed by the Odisha Sales Tax Tribunal, bracket tribunal in essay number 89, bracket ET, oblique 2018, filed by the opposite party dealer, assailing an order dated 31st March 2018, passed by the First Appellate Authority. Confirming the order of assessment demanding tax and penalty of rupees 1943,475 by the impugned order.
I'm only for penalty.
Yeah.
And the petitioner is on quantum.
My lord, I'm sorry to interrupt you, my lord. Dealer was allowed in part. And the penalty levied on the dealer by the assessing authority as affirmed by the First Appellate Authority was set aside. Paragraph. The question that arose in the course of the assessment was whether single coat sand and single coat stone chips procured by the dealer from unregistered dealers was liable to entry tax. Full stop. As noted by the tribunal, there's a genuine doubt about the proper classification of the above goods. And therefore, it could not be said that the dealer deliberately avoided paying the tax. Stop. Paragraph. Although in the present case, the state seeks to urge that penalty should have been imposed under section 9, capital C bracket 5 of the OET Act. The fact remains that with the assessment having been completed under section 10 bracket 1 of the OET Act, the penalty was in fact levied originally under section 10 bracket 2 of the OET Act, which gives an element of discretion to the assessing of authority. Paragraph. In the circumstances, the court is not inclined to frame the question as urged by the department. The revision petition is dismissed.
Item number 18.
My lord, item 17, my name became recorded.
Yes, yes, yes.
Item 18 is against that quantum, and the identical matters have been listed on dated 19th April.
April, is it?
Your Lordship.
All right.
And the identical matter is WPC number 21,375, 2017. All those are entity tax matter and whether sand and chips are
along with WPC number
375,
2017.
17.
On 23rd April.
On 19th April.
19th April 2023. All right. That IA for dispensing that is allowed.
My lord, the question of law has not been properly framed. I may be permitted to reframe the question within a period of 7 days, my lord.
All right. Anyway, before the next date, you can do that. You have to file an IA.
I may be pardoned, my lord.
The earlier matter.
Item number 16, I was here on.
All right, all right. Tell us, 16. All right.
Item number 16.
16.
There is a small defect that I may remove it or can.
All right. Defects be removed within a week. List on. Just say list on 14th February. Defects be removed by then.
Obliged.
Item number 19.
Item 19 and 37 to 49, all are identical matters. Fresh admission. I am appearing for this is the opposite party number 2 and 3.
No, but notice is already issued.
Item
2 to
43,
4.
Your Lordship.
3 to 4. I am sorry. I am
My lord, the plight of the petitioner is that by the order of the apex court, he has deposited 63 crores with interest bearing on that. It's about 100 crores by now. It's lying with the additional district magistrate under the OPID Act for disbursement to the customers who had made the deposit. In the meantime, the additional district magistrate is in slumber and making not much of efforts in distributing the deposits to the respective customers as per the list which was provided to the apex court and then passed on to them through the OPID court here. Now, these customers are straying away to various other authorities like the RERA and
the Consumer Forum.
the Consumer Forum and all that. The state should come forward with a deadline by which they should be able to disburse the entire amount to the depositors.
In that event, if your Lordship will direct, I would get a status report from the concerned ADM that what is the current status of the deposit which he has made, whether it is distributed pursuant to the Honorable Apex Court order, and what is it, then it will be better, I think.
In all these petitions, the common grievance by the petitioner is that although it has made deposit of a certain sum with the additional district magistrate Khurda.
No, Bhubanesh, Cuttack.
Pursuant to order passed by the Supreme Court of India.
He is the competent authority under the OPID.
21st.
My lord, may I interrupt, my lord? Your Lordship may write that ADM revenue and competent authority under the OPID Act.
Okay. But ADM Cuttack and the competent authority
under
the OPID Act 2011.
When the deposit was made.
Yeah. Pursuant to the order passed by the Supreme Court on 21st February 2014. Till date, there has been no disbursal of the sums to the various depositors. Full stop. It is pointed out that as a result, the depositors are also invoking the remedies under other statutes like the Real Estate Regulation Development Act 2016 and the Consumer Protection Act 1986. Paragraph. Mr. D.K. Mantil, an additional government advocate, informs the court that states that on the next date, the court will be informed of the current status of disbursal of the monies deposited by the petitioner.
And the subsequent follow-up action by the.
And the follow-up action taken. Full stop.
My lord, your lordship may direct that it should be filed in shape of affidavit.
Okay. By way
of
an
the
affidavit.
agent, so that it will be better.
Right. 7th February. Sir.
The status report will be filed in shape of affidavit.
7th February.
Yes.
Item 43, your lordship, I have entered my appearance. It may be recorded. Your
All right.
My lord, in some cases, there are private respondents. My learned senior may take notice to the private respondent.
I think notice is already issued in many.
No. Some cases are listed today, first date.
Okay. Which is that?
Item 37 to 49. All are 100% identical matters.
No, but they are fresh matters.
Fresh matters, first listing.
43 only has entered appearance, your lordship. 43. Notice has gone.
No, we've already issued notice in 37 and all that.
Obliged.
We've already been issued. So same order in all of them. Right.
19 along with item number 37 to 49.
Status.
Item number 20.
You say 1 minute. Wherever notice has not been served on any of the opposite parties, fresh notice returnable on the next day.
Private opposite, because
private opposite parties, fresh notice will be issued, returnable on the next day. In which case, we will not keep it for 7th, we'll keep it on a later date. 1 minute. 27th. Make it 27th February. And then you say further defects pointed out by the registry be removed in the meanwhile. Right.
Item number 20.
In the meantime, let there be stay of the proceedings.
No, sir. No, we have not earlier.
Otherwise, repeatedly, several dates we are hauled up.
I know, but let's not do it now.
My lord.
We'll do it on the next date. All right.
Big part.
Item 20 and 21 are similar matters, Millers. But the question involved is all these two applications, Millers, are whether Miller's declaration form F in respect of claim of branch transfer is mandatory or not. Because as your lordship knows, Parliament amended in 2002 making F form mandatory. And this is pre-amendment period, Millers, involving 99-2000. And if your lordship may kindly take pen to page 22, the findings, Millers. Page 22. That's your lordship may kindly start 5 lines from the top. Now the pertinent question arises whether submission of F4 is mandatory in course of branch transfer or not. In this connection, the decision taken by Honorable High Court of Orissa in the case of State of Orissa versus Orissa Small Scale Industry Corporation, 1987-67 ST, page 1 is very much relevant. The Honorable High Court of Orissa has observed that appellant has to satisfy that the movement of goods from one state to another was occasioned, otherwise done as a result of sale. In this case, the appellant has produced conclusive evidence that he has not sold such goods to its branch located Ranchi. The production of individual consignment challan duly stamped in the border check gates exhibited no collection of.
So this was reversed by the tribunal, is it?
Yes. Now, CST, London Tribunal says, had there been C form, inquiry could have been conducted. With such a finding now, I have formulated 3 questions. Your lordship may kindly skip question number 1, not relevant. 2 and 3, page 11. Page 11. First question not necessary. 2 and 3. And this is fully covered by Orissa Small Industry Corporation. Yes.
All right. What do you say?
I am giving a copy of the judgment to your lordship.
Let the question of law.
No, why can't it be allowed?
For the first time, it has become.
All right.
Otherwise, he proves it.
Yeah. Because it's pre-2002.
Let it be for one.
I am giving a copy of the judgment to your lordship.
Let it be for one occasion.
All right. Admit the following question is framed for consideration. Was the tribunal justified in holding that production of F form in proof of interbranch transfer was mandatory notwithstanding the decision of this court in State of Orissa versus Orissa Small Industries Corporation. Volume, you say 1987, 67 STC 262 bracket Orissa. Question mark. So list for final hearing on 27th April.
I pray for no coercive action pursuant to Annexure 4, my lords.
Or in the meanwhile, no coercive action will be taken pursuant to Annexure 4. Right.
Oblation also. In both the matters.
Yes.
Item number 22.
Your Lordship, may kindly dispense with the IA's
Yes.
certified copy.
Correct.
Obliged.
My lord, item 22, my lord, small defects are there. I may be permitted to remove the defect within a week, my lord.
All right. List on.
Yeah.
27th January, defects be removed in the meanwhile.
Obliged.
Item number 23.
Lord, in this case, there are so many defects. One
My
of
lord,
the
this is
defects
the
is
same type of case. Format notice issued, objection was lodged before the collector, then read petition.
No, my lord, why I am showing so? Annex 3,
Your
the
Lordship may
objection,
dispose of in that light that
objection we filed response to the public notice. In order to know whether there is a authenticity or genuineness, as rule provides, sub rule 9 of 15 provides, there is a re-inquiry.
But you have to
By
have
the
patience.
superintendent,
What
it
the
has not been
collector is
done.
doing, you have to have patience on
Because we have
You
given
have
our mobile
recently
number.
given the
When did you
objection.
make your representation?
That Annex 4, my lord, page 21.
Date.
Copy of the objection.
In
Annex
response to
4.
public notice, that in response to Annex 3, the public notice.
Not so
when,
direct
sir,
collector
Date, my lord, 6/12/2022.
Not even 1 month, sir.
Because well, immediately they would recommend case to the commissioner. That is the whole problem, my lord.
All right. If not already dealt with, the objections already filed by the objections filed by the petitioners on 6/12/2022
At Annex 4.
will be considered in accordance with law by the
Collector Jajpur.
Collector Jashpur, and the decision will be communicated to the petitioners.
Giving an opportunity of hearing at least, my lord. The
There is no
village
such procedure. Whatever is the procedure, in accordance with law, and the
rule,
decision shall be made known to the petitioners within a week of its being taken. No further directions are called for at this stage.
before recommendation is made, my lord. Before recommendation is made.
And that is there. That is there. That is, your Lordship has already, my Lord has dictated that.
All right.
One thing I want to convey, so far as Jajpur collector is concerned, my personal knowledge
My lord,
was that he is
mostly,
hearing
my lord,
all the objectors.
my lord, most
He's
of the
hearing.
cases now is from Jajpur.
He is hearing all
Because
the.
after settlement of the OPSUPs, now government for augmentation of
No,
revenue,
collector
this
is
process has been done.
personally hearing all the objectors. One day has been kept for these excise matters. That is, of course, it is.
They are not properly, my lord, following the procedures.
According to you, it is not proper. According to the other side, it is proper. That is a matter for adjudication by the competent authority.
All right. Obliged. My lord, the rest defects may be ignored.
Sorry?
The defects
it is disposed of.
Huh.
It is
Disposed of, that's all.
Obliged. my lord.
Item number 24.
Your Lordship, item 24, I am on behalf of the petitioner. Your Lordship, within a week, I may be permitted to
All right. List on 27 January, defects be removed in the meanwhile. All right.
oblige.
Item 25.
My lord, item 25, my lord. Here in this case, the petitioner is challenging the order that, my lord, under Annexure 7, mainly on the ground that, my lord, surplus 2 of section 71 of the Orissa Excise Act has
Commissioner's
not
order
been,
is
my lord,
revisable.
followed. The
Commissioner's
violation has
order.
not been produced. May I be invite your lordship, have a glance at page 20 of my writ petition, that is annexure, under Annexure 2, my lord. Page 20, in the cross examination and in the deposition, the IO has submitted categorical that I have not produced the seized vehicle before the authorized officer. So also it is not mentioned in my prayer letter. It is a fact that the accused Saurabh Sethi is not the registered owner of the vehicle. It was ascertained from the RTO Sundargarh that Nicholas Tirgi, the present petitioner, my lord, is the registered owner of the seized vehicle bearing such number such and such. It is a fact that the vehicle has not been kept in the Malkhana, but the same has kept within the office campus having boundary wall under the closed watch. It is a fact that the registered owner of the vehicle is not the accused, my lord. Your lordship.
You're not the registered owner.
Yes, I am not the registered owner, my lord.
Then why would they release it to you?
My lord, in that situation, your lordship, again, my lord, have a glance at page 20, the cross-examination, my lord. that is my lord, Suresh Bhai, the IOH categorically stated that I have not found any involvement of Nicholas Tirki, the present petitioner.
No, but why should he release the vehicle to you if you have nothing to do?
I simply pray, my lord, your
No, why should the vehicle be given to you?
Why the vehicle will be given to you?
Well, I am the father of the my lord accused, main accused, that is Sorote.
No, but you may be the father,
It
but why
should
should
be given to the registered owner.
He's not some minor or somebody.
Yes, I do
So why
concede,
should
my
he
lord.
give it to you?
But so far the judgment of Ashish Mahanti is concerned, my lord, the lordship has taken a view in that situation. I pray the writ petition.
No,
may
it's
dispose.
not traceable. Here the accused is traceable. He's not absconding.
No, my lord, he's a retired person, my lord, no involvement in the case.
No, sir. Somebody else is the accused. Your son. He's not untraceable. Ashish Ranjan Mohanty will come in if nobody is traceable. If the original owner is not traceable.
Yes.
But the vehicle should not be, my lord, wastage like this, my lord. The vehicle is the state.
Why is the accused not? You can't. He's still in custody, is it?
No. In excise matters, he is.
I don't know. What has happened to the accused? Where accused?
The accused after my lord is bail out. Bail out from the.
Then why he is not?
Why is he not coming forward to ask for the vehicle?
The accused is, my lord, no role. I mean, the petitioner is no role, my lord. So far.
We're asking about the accused. You're talking about the petitioner. Why is the accused not coming forward? No answer.
Situation, my lord, the vehicle.
My lord, if my learned friend agree, this order can be is revisable under before the secretary under section 6, or your lordship will direct me to file counter affidavit.
No. He is not answering our question.
No. So far as the petitioner is concerned, he has no locus standi.
That's what. So where's the
Because
question?
unless you show that you are the bona fide owner of the vehicle.
No, he's not. He admitted he is not.
He's not.
It's the accused who's his son is the owner.
No, my lord. The petitioner is the owner, my lord. Petitioner is the owner.
We've been asking you throughout. You've been saying you're not the owner.
No. The registered owner is the one of the petitioner. That much role he has. Apart from that, he has no other role.
From where you say that?
No, that's right.
My lord, the vehicle particulars under Annexure, my lord, 1. Under Annexure 1, the lordship can leave a glance.
Nicholas Tirki.
I have Annexure 1, page 19, my lord.
Then why you are saying that my son is?
I don't know why.
Why you are confusing the matter?
The petitioner is the owner, but so far the allegation is concerned, my lord, he has not played any role, my lord.
That's
is
maybe
we are not deciding that here.
The criminal case. Your lordship is not considering the criminal case.
No, my humble prayer, my lord, your lordship may dispute.
So why has the authority refused to release the vehicle in your favor? Let's see that. Why have they refused?
They refused only on the ground that, my lord, that the petitioner is not convinced. That is reflected in the order under Annexure 6, my lord. The registered owner of the seat motor vehicle could not prove to my satisfaction that the motor vehicle bearing so and so was used without his knowledge or connivance of the knowledge or knowledge of the accused. That is the finding, my lord.
My lord, father is the registered owner. Son committed the crime. The vehicle was used. This is the admitted background. So the commissioner said that since the vehicle is used and there is no evidence that it was not consciously used by
How can he prove that? So difficult for him to prove that he was not a.
And in that situation, my lord, vicarious liability is also not attract. So far, the petitioner role is concerned, my lord.
All right. I think that's fair enough.
Your lordship may say that with strict conditions, he will submit some indemnity bond or something like that.
He'll produce it. Yeah. You see, the vehicle belonging to the petitioner was seized because it was found to be used for illegal transportation of 300 liters of ID liquor. ID is?
Yes, my lord.
Spurious liquor.
Illegally distilled liquor. Bracket ID liquor, which is punishable under section 52, bracket A, bracket small I of the Odisha Excise Act 2008. Paragraph. The main accused in the case so registered was not the petitioner, but his son. Full stop. The vehicle was directed to be confiscated by the order dated 18 November 2020 of the Superintendent of Excise Sundargarh. Full stop. In the appeal, the Commissioner, by an order dated 14 July 2021, directed Superintendent to ensure that all the provisions of the OE Act, including Section 71(2) thereof, are complied with. Full stop. The petitioner then filed a petition under Section 71(7) of the OE Act for interim release. Full stop. This was rejected. And against the said rejection, Excise Appeal Case number 36 of 2022 was filed before the Excise Commissioner. Paragraph. The appeal was dismissed only because, according to the Commissioner, the petitioner could not prove to the satisfaction of the authorized officer that he had no knowledge about the vehicle being used for illegal transportation. Paragraph. The fact remains that the petitioner is not an accused in the case. Full stop. If in fact it had been found that he had knowledge of the illegal transportation of ID liquor, he should have been arraigned as a co-accused. Full stop. In the circumstances, requiring the petitioner to prove that he had no knowledge would be placing an unreasonable burden on the petitioner, who happens to be the father of the main accused. Full stop. The court is therefore of the view that the Commissioner was in error in rejecting the petitioner's appeal for release of the vehicle, subject of course to terms. Paragraph. Consequently, while setting aside the impugned order dated 18 November 2020, of the Excise Superintendent and the appellate order dated 13th October 2022. This court directs release of the vehicle in question in favor of the petitioner, subject to conditions that will be imposed by the Excise Superintendent. Sundargarh. Stop. The petitioner will now appear before the Excise Superintendent for the above purpose on 27 January.
Lordship may direct that in case the vehicle is released, the superintendent is at liberty to put conditions and
And the conditions for such release will be specified by the Superintendent of Excise. Sundargarh. All right.
the petitioner will produce this order before the superintendent for compliance.
Yeah. The petitioner will produce a downloaded copy of this order for the Excise Superintendent for compliance. Right. The petition is disposed.
Item number 26.
Item number 26, not pressed, not pressed.
Not pressed. Disposed of is not pressed. In the contempt case, you say since the appeal has now been disposed of, is not pressed, the order of the learned single judge be complied with within a period of 4 weeks from today. The contempt petition is disposed of.
Item number 27.
This one also no instructions. No instructions dismissed.
Item number 28.
Item number 28 become infructuous, Lordship.
All right. Disposed of as infructuous. All right.
Item number 29.
Same order, is it?
Yes.
Despite service, none appears for the respondent. And then same order. Delay, condone, all of that. Right. When is it coming up? March 23rd.
Yes, ma'am.
Some date is
Your lordship already disposed of.
You're appearing. Are you appearing?
No, miss. I'm not. I'm in 30.
No, that's it. Dates have to be given, sir.
That has been changed to 23rd.
No, it will be listed on. I think we've given a date in the.
Yesterday, your lordship has changed the date.
What is 2023.
Item number 30.
No, I have instructions to appear in this case, my lord. Your lordship may call it after 2 weeks. I'll regularize the matter. In the meantime, I'll file my vakalatnama and remove the defects.
All right.
Copy notes are.
List on 24th January. Defects be cured in the meanwhile.
No, your lordship will call.
24th January. Item 31.
31 has become an infructuous, my lord.
All right. Disposed of infructuous.
Item number 32.
May it please. Lordship, this I have come up against the award of the Learned Labour Court, your lordship. These workmen were terminated on the basis of a faulty gradation list without following the mandatory provisions, your lordship. The seniority juniors to where they are still continuing, and also the compensation were not paid to them on or before the date of the retrenchment. But the initial date of joining was not taken into consideration. That has been admitted by the MW1. It has been categorically admitted that the.
Who's appearing for the opposite party?
Ma'am.
You're there.
Hello.
Or yes.
The Labour Court, while passing the award, your lordship, has also not considered that the present petitioner number 1, by that time, he was reinstated back in service since 2007. And presently also after the award, the petitioner number 2 in 2019 also, he has been reinstated back, your lordship.
So what remains? They're all back in service.
He has been reinstated back in service.
What about 3? Only 3 petitioners are there.
3 petitioners are there. The third petitioner, your lordship, juniors to him are still continuing because his initial date of joining is in 88, November 88, 1st of November 1988. And
they're all in their 50s now.
Yes, your lordship. 2 of them are continuing in the service, your lordship.
1 and 2.
1 and 2. But now it's about the back wages, your lordship. And the third petitioner, your lordship, juniors to him are still there. They are still continuing.
No, but there was an interim order in his favor even by this court.
What happened, your lordship, is...
he was already retrenched by then.
No, in 2007, he was taken back. In 2001, they were all retrenched. 2007, the petitioner number 1 was taken back in service, reinstated. And after this award was passed, where the Labour Court has ignored the fact that he was already continuing in service, he has retrenched him. Therefore, he was again terminated, and there was this court, by the order of directed a stay. And after that, he was still continuing in service.
What about 3? Petitioner number 3?
Petitioner number 3, your lordship, he is not in service.
No, that interim order of this court did not help him.
No, your lordship. It was only for petitioner number 1. By that time, petitioner number 2 and 3 were not taken back. Petitioner number 2 has been reinstated in 2019, Your Lordship.
So notwithstanding the petition, you've reinstated all these people, 1 and 2.
The Lordship may see the award. In that, what has happened, my lord, that after that award, my lord, we have re-engaged them, notwithstanding that they were returned in 2001. Subsequently, they were re-engaged.
And they seem to be continuing. 1 and 2 are continuing.
Yes, my 1 and 2 are continuing. So far as 3 is concerned, my lord, that no instruction is with me, my lord, regarding.
What is the finding of the tribunal? Or
Yeah,
labor
Lordship,
court?
page 36.
Labor court.
The reference is regarding the termination of employment of the workmen being the surplus of were terminated from service after abolition of Mahamadi Barrage Quality Control and Research Division Cuttack on due compensation. The workmen have not raised any objection regarding receiving of any less amount of compensation and receiving the same at a belated stage. So basing on the materials available, so that complaints of section 25F of the Industrial Disputes Act were duly complied by the management while terminating the service of the workman. There is no specific evidence available in the case record that any junior to the workmen are working under the management. So in this background, basing on the material available in the case record, I came to the finding that the termination of all 4 workmen by the management with the effect on 1 is illegal and justified, and the workmen are not entitled.
See, this is what she's saying. They were already, 1 was reinstated in 2009 itself.
Well, subsequent, they were
no. By this time, the award is 15 January 2011.
Well,
by this time, petition number 1 had already been reinstated.
Not re-engaged, my lord. Not
whatever you say, sir, he was already working there. This doesn't seem to recognize that he was already working.
No, at that point of time, they are not. In 2001, they were retrenched.
No, 2011, when the order was passed.
Yes, my lord.
He had already been, whatever you say, re-engaged, she says reinstated. Whatever.
Well, subsequently.
So the award does not take note of the subsequent developments at all.
Yes, ma'am. That is the fact.
It doesn't even take note of the initial date of joining, and also that the compensation we paid to them at a very belated stage.
The challenge by the workmen in this petition is to an award dated 15 January 2011 passed by the Labour Court. Bhubaneswar, in industrial dispute case number 115 of 2002. There were 3 workmen involved in the present case. The term of reference of the dispute to the Labour Court period as under. Take from page 30, bottom. Although by the impute award, the Labour Court upheld the termination of the services of the workmen with effect from 1/12/2001 to be single quotes legal and justified. The fact remains that as far as petition number 1 is concerned, in 2009 itself,
2007, Your Lordship.
In 2007 itself, he was reinstated in service. First of this fact was not brought to the attention of the Labour Court. Full stop. It is obvious that if this fact had been taken note of by the Labour Court, it may not have upheld the termination of the services of the said petitioner. Paragraph. In any event, vis-a-vis petition number 1, there was an interim order passed by this court. way back on 14th December 2011. And that interim order has continued. As regards petition number 2 is concerned, it is submitted by counsel for the petitioners that he was reinstated in service in 2019
Yes, Your Lordship. Order dated 25/2/2019.
by an order dated 25/2/2019. So thus it appears that on their own, the opposite party, bracket Water Resources Department,
Yes, Your Lordship.
had either reinstated or renewed petition number 2, thereby rendering the impugn award redundant as far as he is concerned. Full stop. Therefore, at least in respect of 2 of the petitioners, that is petitioners 1 and 2, the respondent department appears to have on its own reinstated or re-engaged them. Full stop. Where is the award page? Which page is the award?
It's Annexure 8, Your Lordship, page 30.
Even vis-a-vis the third petitioner, the Labour Court ought to have asked the management to produce records vis-a-vis the contention of petition number 3 that persons junior to him
Yes, Your Lordship.
had been retained in service. Labour Court ought not to have shifted the burden of proof in this regard to the petitioners, since they were not in control of the records of the management and could not have possibly produced the paragraph. For all of the aforementioned reasons, the court finds that the impugn award of the Labour Court dated 15 January 2011 is unsustainable in law and is hereby set aside. Full stop. The petitions allowed no order systems.
Lordship, I pray with full back pages. With full back pages.
Whatever is there in the award, can't now.
The
beyond-
award says nothing.
All right.
Or else they won't consider the back pages, Your Lordship. May kindly reflect it.
All right. The reinstatement of petition number 3 will be with full back pages. All right.
Obliged.
Item number 33.
Well, there are 2 item number 65 and 64 is the same. It's the depreciation matter.
33, 6,
33.
ITA 64 and 65.
64, 65.
Ah.
It is depreciation matter.
Ah.
They have claimed 25%. Department allowed 10%.
Ah.
So the depreciation is up to 2056.
covered.
Lordship, RV your senior counsel is on his way from the airport. If we can take a passover.
All right. All right. Pass.
Much obliged.
Item number 34.
35 is that ASO matter, Your Lordship has disposed of day before yesterday. That 1608 of 2014 on 2nd January, Your Lordship has disposed.
Same. All right.
Same. 34 and 35.
In view of the order passed with this court on 2nd January 2023 in Reproduction Civil 1608 of 2014 and batch bracket Narottam Rath versus State of Orissa. The impugned orders of the assistant settlement officers in the present petitions is set aside, and the following directions are issued. The same directions. In 3 and 4.
34 and 35.
Right.
Obliged, Your Lordship.
And then para 20 you repeat. Right.
Item 36.
36 also same, my lord, the ASO matter.
All right.
Yes,
Same.
Thirty-seven, 49 already. Supplementary.
Here, my lord, a substitution petition had been filed, my lord, that may kindly be allowed, my lord, in this.
Or substitution. All right.
Supplementary list for admission item number 50.
50.
Sishu Bhavan.
Item 50, my lords, Mr. Samantra is in some personal difficulty today. He's requested for a short accommodation.
The none appeals to the petitioner. Mr. Samantra appearing for the state to be in some personal difficulty today. What do you want? Give me that.
No.
20th February. 20 February.
20. Item number 51.
May I please, Your Lordship? I am appearing for the petitioner, my lord, allowed to do the matter in BC. This is Jagannath Temple and Konarka Temple matter.
Yes.
My lord, my work of Natmandap is in progress. We have called a meeting on 29th of November. All these people of ASI, additional DG and others have come. Now they have taken up what to be done and what not to be done. Now because the pilgrims are there, Ross is there, work is not taken up. After 15 days, work will start.
My lord, my instruction is there. The Director General of ASI core committee meeting will be held very shortly. Then they will go ahead with this because government will took a decision to open another administrative office there only for Puri and and they will monitor the work.
I'm grateful to this court because they have opened a circle at Puri. Man.
All right.
Regarding Konark, you'll be glad to know.
Because a lot of pressure is coming. This Bhubaneswar office is not able to control. This government took a decision after all this monitoring. Correct. That one circle is there, the one superintendent is there. You will only to look at the Konark,
only the
Puri, all this.
Well, that will be another glad in about Konark. 120 years back, what the British government has taken decision, now that has been altered because for the intervention of the Port Mila.
All right.
I'm very grateful to the court.
All right. You see, the court is informed that the Archaeological Survey of India is opening a separate circle office to deal with the monuments, the monument in Konark and the temple of Lord Sri Jagannath in Puri. It is stated that meeting chaired by the Director General of ASI will be held shortly to chalk out a plan for carrying out the repair works in the temple.
Nat Mandap.
In the Nat Mandap of the temple. Correct. An updated status report will be placed before the court on the next date. 16th March. We've given a date.
20th February. Item 52.
No, Mr. Mahanti,
My lord,
we have adjourned it to 20th February.
15th February. Problem.
Item number 52.
Along with me, Mr. Pradhan is appearing, CK Pradhan. Yes. Or
Millards, item 52 pertains to Millards, the transfusion of HIV positive blood in Vimsar,
right.
Budla Millards.
Right.
Pursuant to Millards, the last order served the copies of the affidavit which I filed on 30th of September 2022 with regard to the compliance of the various recommendations by the RDC Millards. Because there was an inquiry. If my lords may be pleased to take my affidavit.
Where is that affidavit?
From para 6 onwards, I've
This affidavit is July. This is September is filed.
30th of September. Thirtieth of September. This 153.
153, is it? Yes, para 6.
Please, Millards. From para 6 onwards, I've dealt with each point, Millards, in seriatim. That is the first point. The first recommendation was with regard to whether the blood bank should be activated immediately with adequate manpower. Please, Millards. That's the first recommendation was that the blood bank should be activated immediately with adequate manpower with requisite qualified technicians. So with regard to that, Millards, with reference to the above recommendation, the next page, Millards, the director of IMSAR with a letter so-and-so has reported that at present the blood bank is running with requisite manpower, including properly trained and qualified lab technicians. Apart from that, Millards, there was an inspection in the year 2020, and it was found that the blood bank was functioning with adequate space, equipment, and staff with availability and a wide range of blood testing facilities. They also found that standard operating procedures are being followed in the said blood bank. So with regard to the first recommendation, this is the compliance. Then, Millards, the next page. This pertains to, Millards, the compensation that is to be awarded. The damage caused to the patient so-and-so due to transfusion of infected blood is neither repairable nor recoverable. However, I recommend compensation of 5 lakh each to the patients. Besides, I also recommend that the entire cost of the treatment of both the patients should be borne by the government for the rest of their life. With regard to this, Millards, there was a complaint filed before the OHRC and the NHRC, I'm sorry. And the NHRC had awarded 1 lakh compensation. That 1 lakh compensation has been given. But as per this affidavit, the 5 lakh compensation, the file is pending before this Honorable Chief Minister because it will be dispersed from the Chief Minister's special.
Pending with the Chief Minister since when?
Millards, I'll just take instructions. I don't have the exact date, Millards. I'll take instructions on this. So, Millards, with regard to this, that 5 lakh has not been given. The other issue with regard to giving medical facilities for the rest of their lives, My lords, it was found that page 6, my lords, the first paragraph.
Yes.
If I may please. With reference to the above recommendation, it is submitted that in the meantime, 2 NHRC cases bearing so-and-so were filed by
No, that's
Radhakant.
okay. You paid 1 lakh to one, the others test
Yes, my
negative,
lords.
but this 5 lakhs, you're not given a date.
Yes, ma'am. 5 lakh, my lords, we'll pay. The date is not given as to since when it is pending. I'll take instructions if it has already been dispersed or not. Then, my lords, the third point. During the period of incident, Dr. Rajendra Kumar Patnaik, Samita Patel, lab technician, and Smriti Ranjan Patnaik, data entry operator who were on duty, have utterly failed in discharging their duties, for which they should be adequately punished for gross negligence in performing their assigned works. They are squarely responsible for this unfortunate incident. I therefore recommend departmental proceedings should be initiated. With reference to the above recommendation, it is submitted that Ms. Samita Patel, the lab technician, has been disengaged from service with the dated 18/6/2016. Smriti Ranjan Patnaik, data entry operator, has been disengaged from service on the same date. The medical officer, Dr. Rajendra Kumar Patnaik, was placed under suspension. He was proceeded under Rule 15 of OCS rules. The said DP was concluded and the following punishments have been given of censure and withholding of 1 increment without.
It's all right. Yes. 9, para 9.
Yes, yes. This is point number 4. Gross irregularities have been found in the functioning of the blood bank because they were not maintaining the books and accounts. So that, my lords, the next paragraph, with reference to the above recommendation, it is submitted that the director of IMSAT intimated that several corrective measures have been taken for smooth functioning of the blood bank, and books after internal inquiry has been done by the IMSAT authority. It is further submitted that the disciplinary proceedings have been initiated. On the bottom of the page, minutes on the next page, a special audit of the blood bank has also been done by Assistant Audit Officer for the year 2015-16, and as per the special audit report, a sum of rupees 2.48 lakhs has been recovered from Dr. Sushant Kara, who was the in charge of the blood bank. It is further submitted in view of the recommendation of RDC for investigation of irregularities of blood bank by an independent state level inquiry agency like crime branch. The file is placed before the government for constituting the committee. Then page 13, para 10. Ex-Superintendent Dr. L.K. Das also gave patronage to Dr. Kara, who was the in charge, and not improved the functioning of the blood bank. Dr. B.M. Mishra, Superintendent, has taken charge just 1 month back. With reference to the above recommendation, it is submitted that the Director of IMSAR has intimated that the ex-Superintendent L.K. Das has retired from service on 31/8/2019 on superannuation. The medical officer in charge, Dr. Kara, was put on suspension with a so-and-so, and a sum of rupees 2.48 lakh has also been recovered from him. Para 11, Millards, page 14. Yes. This is the 6th recommendation. Out of 11 laboratory technicians, only 2 were trained. With reference to the above recommendation, it is submitted that the Director of IMSAR has intimated that out of 17 number lab technicians presently working in the blood bank, 9 numbers are trained at designated centers.
I think they've taken action
Yes,
mostly.
my lord, but only 2 things, my lord, the compensation and the crime branch investigation. There's a 2 things. Let them
take it to the logical end, sir. A detailed affidavit has been filed on 30th September 2022, informing the court of the action taken on the recommendations of the Revenue Divisional Commissioners, as contained in his report. So the court has been informed that as far as the compensation amount is concerned, for dispersal of the compensation of rupees 5 lakhs, the file has been moved to the office of the Chief Minister, and if not already dispersed, steps will be expedited in that regard. A direction is issued to disperse the said compensation amount to, what's the name of the person?
Well, it's Siddheshwar Pradhan and Jay Narayan Sahu.
Page 5, paragraph 7, my lord, of the affidavit. Page 5, paragraph 7.
Sri Siddheshwar Pradhan. There's only one person now, right?
But 1 month,
Two person, my lord.
two persons, but out of them, one found negative.
Yeah, so not
Other person
only
was
only
found
one person.
Janan Saw, he found negative, man.
That's all. So only Siddheshwar Sahu. Full stop. The said amount now shall be disbursed positively within 6 weeks. Paragraph. As far as the departmental proceedings are concerned, the affidavit has set out the details thereof. Full stop. As far as the criminal case registered, where are the details of the FIR, sir?
There is no affair, my lord.
No, my lords, the criminal case, my lords, that is also, my lords, pending before the government for sanction. My lords. Only the departmental inquiry has been
You
initiated
say,
and lodged.
however, as far as the criminal case is concerned, it is stated that the file for obtaining sanction is still pending with the government. Full stop. The orders in this regard be passed positively within 8 weeks from today. Paragraph. If there is non-compliance with the above directions, it will be open to the petitioners to seek appropriate remedies in accordance with law. The petition is disposed of.
Item number 53.
It's a public interest litigation, though at a belated stage, the OP has neither disputed nor denied the averments made in the prayer made in the PIL. Your lordship kindly see the prayer.
My lords, item 53, my lords, I'm filing my counter affidavit.
Your lordship kindly see the last order. And the orders right from the day 15/4/19. It's a insurance crop.
You're not filing the reply, sir. Better have the reply.
Out and out, the
reply of the
instead of
statement on
100%,
record.
they've given 3% to the insurance.
A copy is handed over to Mr. Mishra and comes to the petitioner. It's for me to file a rejoinder there too for the next stage.
Your lordship kindly see the last order. And
No, you can file a rejoinder.
This one of the opposite party, I think.
No, this is all about crop insurance and all of that.
Only 8. 1.
He's a collector, sir. So he will know best.
Then so what? There are many other opposite parties. Your lordship kindly see. Wait.
Yeah, other opposite parties, if
Your
you
lordship
file a
can see.
reply.
Here,
We've already granted last opportunity, sir. So you file a rejoinder to this affidavit. List on.
your lord,
16th March.
Their implemented appearance will be noted.
All right.
only the counter to the opposite party number 8.
What else to do, sir? We already given the last opportunity.
No, they have not filed, not disputed. So that goes.
I know, but next hearing we will, after dealing with all
the 8 is the collector Balangin, my lord.
Correct.
Virtually, he has got nothing to do counter because he has given a report in favor of the petitioners.
So maybe we don't know. Just see the affidavit.
My lord.
Item 54.
And for the petitioner, your lordship directed for filing of the counter by the union government and state
We
government.
need some more time, man. This wildlife matter, man.
The defects have still not been removed.
My lord, that is a, my lord.
No. Last time, 13 July, the.
My lord, within 2 days, I will remove the defect. Within 2 days, I will remove the defect.
Mr. Raut assures the court that defects will be removed within 2 weeks. 2 days.
My lord.
Mr. Padi, appearing for the NHAI. No, for the.
My lord, OP number 6, my lord.
For the Union of India, OP number 6 states that he'll file his reply positively within 4 weeks. Rejoinder for the
My lord, state is to file the counter, my lord, because this honorable court has held that there is no
other opposite
sanctuary.
parties shall also file the replies within the same date. For it. List on 1st May.
My lord.
Along with Mr. Prabhu Prasanna, where is appearing?
Yes.
Obliged.
Obliged.
Not yet filed.
My lord, I pray, my lord, till then, my lord, effect of notification shall be stayed, my lord. Because the people are suffering, there is no sanctuary, and by virtue of this notification, they are debarred from utilizing their land.
All right. Yes.
Item 55.
55, my lord. One is not there, 55. 55. CNR ଦେଖଉଛି
55, we place some 2 weeks time to file counter.
Who's here for the petitioner?
Yes, Lord.
As replies be filed within 8 weeks, rejoined up to the next date.
55, if state is a party, please serve a copy to us.
4th May.
Item 56.
Please, my lords. In this case, my lord, the state has already filed the counter. Your lordship directed me to file a rejoinder affidavit to the counter. My lord, I beg to say that it is a voluminous matter. So your lordship may kindly urgent me, allow me some more time so that I can.
All right. Last option is granted to the petitioners to file rejoinder for the next date. Just on 9th May.
9th February.
9th May. Sir. Item 57.
The money granted under the Mahatma Gandhi Rural Employment Guarantee Scheme has been totally siphoned by the public officers.
For
They
the
have
Lokayukt, sir. Lokayukt. For the subject matter of the petition, the petitioners may well approach the Lokayukt in accordance with law, granting them that permission. The petition is disposed of. Right.
Item 58.
Item 58, my lord. It is a PIL.
Item 58, my lords, it's regarding opening of the PHC Achyutpur. It was pursuant to my lord's last direction. Again, it was placed before the authority. My lords, I filed my affidavit on 15th of December.
My lord, if I may indulge your lordships, in the last order, your lordships had sought instruction from the state that if there is a demand for opening of the PHC, clearly there is a need felt by the villagers, and they may add up some villages to.
Please, my lords, may see my affidavit, my lords. My lords, para 4 of my affidavit, if I may please.
Yes.
That pursuant to the directions of this Honorable Court, the issue regarding opening of PHC at Achyutpur was again examined by the Director of Health Services. The DHS has stated that a few more villages will be tagged to create the facility.
Again, same problem.
The actual population covered in those original villages will decrease. So at a future date, this was.
All right. Well, the population is according to the 2011 census.
Yeah, whenever that's revised. An affidavit dated 15 December 2022 has been filed, wherein para 4 it is stated as under. Reproduce para 4. Mr. Mahanti, your instruction states that as and when the population figures are revised, in the next census, the issue will be revisited and a decision taken to stop. At this stage, no further directions are called for. The petition is disposed. All right.
Great. Item 59.
59, your lordship, order dated 49. Yes. Your lordship, order dated 49, 2022. Your lordship directed for framing of a policy. I have received an instruction that the draft policy has been prepared. It will be finalized within 2 weeks.
All right. It is stated that a draft policy has been prepared and will be finalized in 2 weeks. It be placed on record with an affidavit before the next date. List on 29th March. Public. All right.
Item number 60.
May please, my lords. This is a case of reopening for the assessment year 6-7. This case has been admitted in 2019. My lords, what has happened, having failed to knock me out before the tribunal, before this honorable court, arm twisting method was adopted. By reopening the assessment, under Annexure 1 at page 13. This is now never-ending litigation. Annexure 1, page 13, Lordship may be pleased to see. The assessment for the assessment year 6-7 was reopened. Then I asked for the reasons. The reasons was communicated under Annexure 7 at page 59.
Unexplained investment in house property.
Yes. And this has been discussed. The first one, which they say that for this reason, it has been reopened. Lordship, I'll take to the original assessment order. That is Annexure 3 at page 16, my lords. It starts, and the relevant portion, your Lordship will find at page 24. In connection with the query relating to the difference of 77,48,471, the table investment on immovable property between the value quantified by the valuation cell and that of the value furnished by the assessee before the valuation
So
cell.
this was already considered by the AO.
Yes. Then second one. Each one has been considered.
It's only change of opinion.
And what has happened, my lord, the counter affidavit they have filed. Lordship will see the counter affidavit original file. Every day they are filing counter affidavit. Today also they have filed a counter affidavit. That is how it's never ending.
In second case. In second case, not in first case.
Okay, but both the cases are same.
Only
page 5.
All right.
Only the page 5, Lordship may be pleased to see original assessment made under section 153A, 143.3 has been quashed by the Honorable Income Tax Appellate Tribunal on technical ground. There was no such on technical grounds. It should have been English is also, I think, is a defect. On technical ground, it cannot be technically ground. Then Lordship may see it has been directed to make assessment in the manner other than 153A. So where is the new material? That is the exact question. And I'll just give one judgment. I'll not bother Lordship. Your own Lordship's own judgment in October that Anila's Tuli mailers, I'll give. And your Lordship have considered all the judgments. Yeah. Oh. And it is more than 4 years. 6-7, you are reopening by the consent of the commissioner. In 2013, my lords, Annexure 1, I think, has been issued. 18/12/2012. So it's more than 5 years. That's all, my lords, is covered.
No, let him appear before the assessing officer.
Why? After all these years, 2013 onward is there. Now no point sending him back.
It is a matter of 2006-7 and notice has been issued on 18/10/2012.
Very soon at this rate, 20 years will be over. If he goes back to the AO now. All right. It's quashed. Petitions are allowed. I'll pass the detail on. All right.
Obliged. I would.
Both writ petitions.
Both the writs.
All right.
Only assessment rate is different. Much obliged.
Counter has been filed here.
Something or the other. Keep them busy.
But they are not able to.
All right.
Let's
I'll take it on record. Sorry.
Item 61.
This matter, whether urban local bodies are amenable to service tax for the statutory duties that they function, is now seen before the Honorable Apex Court.
I see.
In Civil Appeal number 6303 of 2016.
Informs the court that the question whether urban local bodies are amenable to service tax is pending consideration before the Supreme Court of India. In
civil appeal number 6303.
There's two matters pending, my lord.
Right. And
Second last page.
And SLP civil.
BDA Bhubaneswar Development Authority.
Both these issues not pending. So far as the rentals issues space, that also pending before the Supreme Court for adjudication.
And SLP civil 9672. The present petitions are adjourned sine with liberty to the parties to mention it for listing after disposal of the aforementioned cases.
May I suggest one matter is I thought if you agree, it will be disposed of because one matter the notices has been challenged. Thereafter, so-cause notice has been both the cases. So that is I think that is influxuous. If you agree, that may be disposed of. One matter.
All the matter
because that is no more
so-cause notice.
Because so-cause notice has been considered and your lordship has granted protection. If it's agreeing, Lord, I don't have any.
It's all right. Let's move to
I'm appearing Lord 3 cases, Lord. I filed the memo up today.
Item 62.
May I please, my lords. My lords, here the assessment order was challenged in first appeal. And the first appeal was not entertained on the ground that pre-deposit is not made, my lords. In the meantime, my lords, they have recovered the amount of more than the pre-deposits required. What I humbly frame, my lords, let me, my first appeal be hard on merits.
Your lordship, this against the first appeal, the petitioner has filed the second appeal before the
that we have withdrawn.
That is pending.
That is then we have withdrawn. That we have withdrawn.
Answer for the petitioner informs the court that the pre-deposit amount for the first appeal has already been recovered from the petitioner. In that view of the matter, he does not press this writ petition with liberty to pursue the first appeal pending in accordance with law. Dispose of is withdrawn with liberty is straightforward. First appeal is to be restored.
My lord, otherwise
subject to verification.
Subject
to verification of the payment.
Unless
your lordship, let him pray with the evidences. Your lordship, my respectful submission, let him pray.
The entire demanded tax has been recovered from you.
No, my lords, the pre-deposit,
only pre-deposit.
20%.
According to the first appeal, that some orders to be set aside, right?
Your lordship,
what is the date of that order?
My lords, Annexure 2.
According to the order dated 28 November 2014.
14.
Of the Additional Commissioner of Commercial Taxes bracket appeal, South Zone Berhampur, in appeal case number AA bracket ET 31/2014-15, is hereby set aside, and the aforementioned appeal is restored to the file of the Additional Commissioner of Commercial Taxes bracket appeal, where it will be listed for directions on 1st March 2023. A copy of this order be sent to the said authority forthwith.
Your lordship, subject to verification of that amount, whether that amount has been paid or not, just no evidence has been produced here also.
Yes, subject to verification, my lords. I don't have any objections.
But what does that mean? Who's going to verify it? When we come up there, that authority will decide.
Yes, ma'am.
He's already withdrawn this. Yeah.
Have you already withdrawn the second appeal?
Yes. Second appeal we have withdrawn.
Item 63.
Obligement.
Let's see. Item number 63, even it is that 40-5 penalty, twice penalty.
It's not 40-5 penalty.
Let me. I'm saying for adjournment. Let me. Your lordship, what I pray, your lordship, a short counter is required to file because your lordship, so motor revision against that assessment order, so motor revision has been filed, and against that so motor revision order, appeal has been filed. Against the appeal order, this revision has been filed.
I just place it.
What I pray, your lordship, let a short date may be given. I may be permitted to file a small counter, your lordship, only on that particular issue, whether this is assessed income or not, your lordship.
Because my learned friend will have an additional duty to satisfy your lordships about the jurisdiction, my lords. The lordship would kindly turn to page 16.
Let him file the
what has happened, my lord? The sales tax officer passes the original order under section 42, my lords. Now, my lord, the additional commissioner appeals Lord, he goes for a suo motu revision, Lords. My humble contention, Lord, your Lordship have already seen this notification. Nowhere, my Lord, the additional commissioner appeals have been, my Lord, empowered under section 79(1) by the commissioner, my Lord, to hear appeals or initiate suo motu proceedings, my Lords. What has happened, my Lord, your Lordship have heard in that earlier occasion in WPC 22064 of 2019, where your Lordship has specifically said, my Lords, that this particular, your Lordship has not quashed this notification, but your Lordship would appreciate, my Lord, your Lordship may kindly take up that notification. I may hand over a copy to my learned friend, my Lords. Here, this is a notification dated 5/6/2018. And your Lordship would appreciate that this 79(1) power is given to the additional commissioner of sales tax heading a territorial range. So here, my Lord, if your Lordship would kindly turn to page 16, it's the sales tax officer who passes it. And the suo motu, my Lord, revision, my Lord, if your Lordship would turn to page 26, my Lords, is initiated and passed by the additional commissioner of sales tax appeals. So additional commission of sales tax appeals has nothing to do with suo motu per initiation of the suo motu proceeding under 79(1). He's not empowered, my Lords. So the entire initiation.
All right. So one of the issues raised by the learned counsel petitioner is that in the present case, the initiation of the invocation of the revisional jurisdiction suo motu by the additional commissioner of sales tax appeals is without jurisdiction. He refers to a notification dated 5th June 2018 issued by the Finance Department.
No, it's by the commissioner.
All right, by the commissioner, ET and GST Odisha. Copy of which has been handed over to Mr. Mishra, learned counsel for the department. Paragraph. Mr. Mishra states that he will file an affidavit specifically dealing with the above issue before the next date.
The interim order dated 6/11/2019 may continue.
Yeah, interim order to continue.
Yes,
9th May.
9th May. Much obliged.
Item number 64.
My Lord, this is covered by case of automobiles, my Lord.
Let's see, we have the Fast Appellate Authority has accepted that there is no 39/42/43 and set aside the matter for press assessment. But your Lordship is very clear yesterday.
Upheld in the
following the decision
still, my Lord.
case of automobiles, the impugned assessment order and the consequential demand notice are hereby quashed. The writ petition is disposed of. The above. All right.
Deeply obliged.
Your Lordship, it is the set aside order. So the first appeal order may be quashed and consequential order may be quashed. In the Fast Appellate Authority has admitted that there is no 39/43 so and so, and is set aside the matter for press assessment, and accordingly assessment has been completed pursuant to the direction of the Fast Appellate Authority. So your Lordship,
all right.
that
you say the order of the First Appellate Authority and the consequential assessment order and demand are hereby set aside. All right.
Your Lordship.
My Lord.
Item 65.
My Lord, item 65, my Lord, challenge has been made to the IGST rate notification number 8/2017 and 10/2017, your Lordship, in case of levy of IGST on ocean freight, your Lordship. And this is no more a recent trigger, your Lordship. My Lord, as well as this honorable court in several cases has already held that on ocean freight, duty is not leviable. IGST is not leviable, your Lordships.
Now
So,
there's a Supreme Court judgment, no? Ocean freight.
yes, my the Supreme Court of Mohit Mineral have also been followed by some my lords, your Lordships. Let me share a copy of this orders with my lords, your Lordships.
I see. All the Supreme Court. Okay. Supreme Court order.
The Paradise Hospital is a great, it is a detailed order, page 1 to 54, your Lordships.
Right.
I state invite to the page 53, my lords, annex 8, serial number 8, your Lordships.
Right.
Page 53, serial number 8, in view of the authoritative pronouncement of the Honorable Supreme Court confirming the decision of Honorable Gujarat High Court, rendered in the case of Mohit Mineral Private Limited versus Union of India,
correct.
2020.
Yes, I'm appearing.
All right. You see, in view of the judgment of the Supreme Court of India, Mohit Minerals Private Limited versus Union of India, 2020 in the review of the judgment of the Supreme Court of India in Union of India versus Mohit Minerals Private Limited, 2022, SEC Online 657, as followed by this court in its judgment dated 1st August 2022, in its petition civil 1684 of 2019, bracket Messrs. Paradeep Phosphates Limited versus Union of India. The notification 10/2017 integrated tax bracket rate and notification number 8/2017 integrated tax bracket rate dated 28 June 2017 and the corrigendum dated 30th June 2017 to notification 8 of 2017 integrated tax bracket rate is hereby quashed. The writ petition is allowed to order assistance.
Obliged. Item number 66.
66, my lord, this is regarding Tran 1. Let it come next week so that I can obtain instruction. What is the present status of the Tran 1?
This might have been impromptu because the Honorable Supreme Court has directed to file all the Tran 1, Your Lordship, to open the portal for a specific period and whatever defect, all those have been filed. But for that reason, this matter must have been infructuous.
So,
because here the allegation is that the petitioner has filed the manual Tran 1 due to some defect, and that manual Tran 1 has
Supreme Court order. You have the copy of the Supreme Court.
Your Lordship, Supreme Court, I am submitting that order before launch, Your Lordship.
Supreme Court has given a particular
Your Lordship, I'm sorry.
and extended for 1 month more. So that is the last.
Your Lordship, 2 months, and subsequently also extended 1 month.
In view of the order dated dash of the Supreme Court of India in dash, extending the period for filing Tran 1, the issue raised in the present petition has been rendered infructuous and it's disposed of as such.
And 67.
May it please your lordships. My lords, this is that case, my lords. 8 years before, so-called notices were given, hearing were afforded. After 8 years,
adjudication order.
The case and your lordship on Tuesday has quashed. That is, of course, a central exchange. I was sitting in the court, so I remembered that, and immediately I mentioned that audit come. I think Mr. Misra is
all diary.
Call book. Your Lordship is absolutely right. I'll file a small counter to this.
What is that?
My Lord, because so many cases are still pending and it has been fixed. Your Lordship has fixed it to April 25th.
Which one?
Other cases. On the same issue.
I see. All right. At the request of Mr. Chaudhary Satyajit Mishra, and standing counsel for the department, list on 25th April 2023. Affidavit, if any, by the department be filed by that date.
Much obliged.
And impugned order, my lords, doesn't say what is the reason of passing the order after 8 years. That is the thing. And I have filed, my lords, IA, interim stay, my lords.
All right. Till the next date, no course of action.
In all these cases, my lords.
Right.
I've given also appearance memo.
All right. Till the next date, no course of action be taken against me.
Much obliged. In all connected cases.
Yes.
My lords.
Much
obliged.
Item 68. 68 were not pressed. Both the matters.
Disposed of as not pressed. All right.
Item number 69.
May I please? It's relating to stock lifting of MGQ minerals for the period 15-16 minerals. And the main reason for which it was done was because the shop of the petitioner.
So in all these cases, I think we're going to the
commissioner in appeal.
Right.
That's the main reason, my lord. My shop itself was demolished
on
29th of July 2015 because of the expansion of the road.
All right. There's a standard order we're passing in these matters.
But still, the demand notice is against him. He has to get it passed, or he has to see the appeal.
Your lordships have passed a conditional stay order, and I have complied with that direction for payment of money, my lords. That if your lordship would kindly see, my lords.
5 lakhs.
5 lakhs I've already deposited.
All right.
So, Your Lordship, I'd only pray, my Lord, I'll file an appeal under Rule
Or-
60, my Lords.
Right.
But let that stay continue till disposal of the appeal.
Correct. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file an appeal.
Before the commissioner.
Yeah,
Rule
before the excise
252.
commissioner against the impugned demand notice. If such appeal is filed not later than 1st March 2023, accompanied by an application for delay, citing the pendency of the present petition as a reason for the delay, it will be considered in accordance with law by the commissioner, excise commissioner. The court clarifies it has not expressed any view on the matter. If the appeal is filed within the time stipulated along with an application for interim relief, then till such time an order is passed thereon by the commissioner, excise commissioner.
Till disposal of the appeal, my Lord, because I've already paid that amount, my Lords. Let it be till disposal of the appeal, my Lord. Your Lordship need not.
They will not take any coercive stay because
No, now I have lost my
Still
business.
demand-
I have lost my business, but still I've paid, my Lord. Your Lordship may kindly consider.
the satisfaction of the client,
With
my
the new-
learned senior is asking for this. Because there is actually no threat.
No, we can't say, my Lords.
It's all right.
No, may I pray for till end of this appeal, my Lord? Your Lordship may fix a time limit.
All right. You say, considering that the petitioner has already deposited rupees 5 lakhs pursuant to the interim order passed by this court on 28th March 2018, is directed that the disposal of such appeal, if filed within the time stipulated, the interim order passed by this court on 28th March 2018 will continue.
And I'll take all these contentions regarding. Really obliged.
Right. The petition is disposed of there. As withdrawn with liberty is prayed for in the above terms. Right.
Much obliged.
Right.
Item number 70.
My Lord, in item number 70, notice was issued. State has not filed counter. My Lord, if they want to file counter, Lordship may permit them. Or I can place the matter, my Lord.
This is also demand notice against.
This is an appeal against demand notice. This is something, my Lord, my specific challenge in the writ petition is government have not permitted interchangeability for excess drawn of MGQ as against short drawn of IMFL for the year 17-18, while they have considered interchangeability in the case of other licensee. Those who have approached this honorable court.
On same points, he has got many cases and matter has been remanded. He will raise this point before the appellate authority.
Correct. Counsel, the petitioner seeks leave to withdraw the present petition, liberty to file an appeal against the impugned demand notice before the excise commissioner. If such appeal is filed not later than 1st March, accompanied by an application for continuation of delay, citing the pendency of the present petition as the reason for the delay, to be considered by the excise commissioner in accordance with law. You see, if the appeal is filed within the time stipulated, accompanied with an application for stay, then till such time the commissioner passes an order thereon, the interim order passed by this court on 8 August 2018 will continue. The writ petition is disposed of, is withdrawn, liberty is prayed for in the above terms.
My Lord may indicate if at all I am aggrieved, I'll approach this honorable court.
No need to say all that, sir.
You have to approach the revisional authority.
All right.
Item 71.
My lords, I appear for the petition in item 71. The pleadings are complete. I pray that the matter be listed for hearing on a fixed date.
That IA 9037 is become infructuous, it is disposed of. In the main petition, you say pleadings are complete, list for final hearing on 27 June.
Item 72.
Grateful, my lords.
In item 72, I am appearing from opposite party for opposite party number 2, my lord. Your lordship may give me 7 days time to file counter because annexure 1 is under challenge.
72 is Abhay Tiwari.
72.
Opposite party number 2 is excise commissioner.
I am appearing for opposite party number 5, Odisha State.
OSBC.
Odisha State Beverage Corporation. Annexure 1 is under challenge. I'll file counter, my lord, only 7 days, my lord.
Why
My Lord, government has also not filed counter. Notice was issued, my lord.
All right. The replies we filed within 8 weeks to join up the next date. List on 28 June.
28th
June. My lord?
28th June.
28th June.
June.
Item 73.
My lords, I'm appearing item 73. My lords, may give us a passover.
All right.
No, my lord, I am appearing. I'm there.
All right. All right.
I take back my words here.
I'm there.
Yes.
My lord, if your lordship will straight away go to page 8, paragraph 6 of the High Court, which formed the basis of the High Court order. Your lordship has page 8.
Yes.
That is the basis. Paragraph 6 is the basis of the High Court order. If your lordship will look at that order, taking into consideration the directions of the Honorable Apex Court in the above cited Supreme Court decisions, the Honorable Apex Court, again in the case of State of Tripura and others, in paragraphs 6 and 7, came to hold as follows. Now, the Honorable Supreme Court held that if there are no promotional avenues, at least you should give the employees a time-bound advancement pay scale and an assured career progression every 15 years, after 15 years, 25 years, and 30 years. Now, our categorical submission before the before the learned single judge in our counter affidavit was that we have given him 15 years, one, a time-bound advanced pay scale, and two, assured career progression after 15 and 25, after 25 and 30 years. Now, if your lordship will look at my appeal, the writ appeal at page 7, your lordship has it?
Yes.
The learned single judge has relied upon that judgment of the Honorable Supreme Court to pass this order, issuing a mandamus to the appellant to promote them at two stages promotion. Now, if your lordship will look at page 7 of my writ appeal, your lordship has it?
Yes.
About 5-6 lines from the appellant pleaded that the appellants have framed the time-bound advancement pay scale scheme and other described as assured career progression, revised assured career progression, providing higher scale of pay to the employees to those who are not getting promotion to avoid stagnation in one scale of pay. The respondent has availed first TBAPS on completion of 15 years.
Anyway, what's the who's for the workman?
I am for the workman.
Ah.
My lord, I need some time, my lord.
All right. At the request of so and so appearing for the workman, list of final hearing on 28th June 2023. Interim order to continue.
Beg your pardon, me, Lord. That item number 66, that order of Honorable Supreme Court dated 22nd July 2022. In case of Union of India and another versus Philco Trade Center Private Limited, SLP number 32709-32710/2018, Your Lordship.
All right.
Obliged.
Yes.
Obliged, Your Lordship.
Item number 74.
Lord, item 74. Lord, I challenge an order where the Honorable Single Judge has directed disbursement of provisional pension to an employee who is facing a departmental proceeding. Now, Lord, the only impediment here, Lord, on my part, is the rule which governs us. That your Lordship will find at page 81. Admittedly, this person, this employee, has been superannuated during pendency of a disciplinary proceeding. And Rule 45 governs the field. Page 81.
Yes.
Page 81.
Yes.
An officer or employee who is under suspension on charge of misconduct and who attains the age of superannuation shall be deemed to be in service even after the age of superannuation for a specific purpose of continuation and conclusion of the disciplinary proceeding and issue of final orders thereon. The officer or employee who is under suspension shall not be eligible to any subsistence allowance for a period beyond the date of superannuation. The officer and employee who disciplinary proceeding has been initiated shall cease to be in service on the date of superannuation, but the disciplinary proceeding shall continue as if he was in service until proceedings are concluded and final order is passed in respect thereof. This is important. The officer or employee against whom disciplinary proceeding has been initiated shall not receive any pay and or allowances after the date of superannuation and also not be entitled.
What happened to the disciplinary proceedings?
No, disciplinary proceeding, he has preferred a writ petition and got it stayed.
Why have you scored a self-goal like this?
My lord.
You score a self-goal, you challenge the disciplinary proceedings, get it stayed. You will not get provisional pension then.
My lord, kindly.
Allow the disciplinary proceedings to carry on there.
Yes, my lord. Your lords may kindly turn to
disciplinary proceeding.
This is a regulation what my London senior is referring. That is 2010. The 2010 regulation 45(4), my your lordships, my lord, the officer or employee against whom disciplinary proceeding has been initiated shall not receive any pay and or allowances after the date of superannuation and also not be entitled for payment of retirement benefits till the proceeding is completed and final order is passed thereon, except his own contribution to contribution provident fund, my lord.
Yes.
But my humble assumption before lordships is that this pension is given in lieu of the contribution provident fund.
No.
If your lordships for a moment turn to page 119, that is the regulation where it mentions about provisional pension.
Right.
Your lordship for a moment turn to page 119.
All right.
That is regulation 2018. 2018 regarding, I am on provisional pension, your lordship. Page 119, regulation 44. Well, provisional pension. Any employee who has retired on attaining the age of superannuation or otherwise, and against whom any departmental or judicial proceedings are instituted or where departmental proceedings are continued, a provisional pension equal to the maximum pension which would have been admissible to him would be allowed subject to adjustment against final retirement benefits sanctioned to him upon conclusion of the proceedings. But no recovery shall be made where the pension finally sanctioned is less than the provisional pension or the pension is reduced or withheld, either permanently or for a specified period, my lord. In case referred to sub-regulation 1, the gratuity shall be paid to the employee and only on conclusion of the proceeding, any recovery is to be made, my lord. Gratuity we are not getting, my lord. I am on provisional pension. If your lordship for a moment, turn to page 122, your lordship. 122, my lord. Your lordship, kindly see, my lord, this page 50, my lord, regulation 50, the last two lines. A member of the fund and refunded the entire amount of bank's contribution within the time stipulated under this regulation, my lord. These regulation 41 and 44 apply pension other than the family pension shall become payable effective date or as the case may be from the date of following the date of retirement, whichever is latter, if the employee has exercised his option to become a member of the fund. I exercised my option of the member of a fund and refunded the entire amount. We have refunded the entire amount. So far, Provident Fund is concerned, my lord. So far, this CPF is concerned. Now, my lord, regulation 44, your lordship, similar 2018 regulation, it says, my lord, we are entitled for provisional pension. I am there before a lordship for provisional pension, my lord. So that the London single judge.
You allow the disciplinary proceedings to go on now.
Yes, but that will be your lordship.
You file a memo before us that you withdrawn the.
No, there is already an order by your lordship. There is already an order by your lordship, but still it is not being listed. That your lordship may kindly see order dated 28/5/2020. Order number 4. 28/5.
There your lordship directed to
last paragraph. We also direct the registry to list the writ petition bearing WP so and so filed by the registrar for final hearing as.
And above that, my lord, there is direction to pay the
pension is being paid.
No, my lord, this is not paid as per my instructions since last 2 months. They have not paid.
It's a simple thing. You file before us an order showing you've withdrawn your writ petition. That's it.
And the disciplinary proceeding is already over. Only the
you show us that you've withdrawn writ petition civil 16510 to 2015.
Unless I get the instruction, my lord, your lordship, I cannot.
Counsel for the respondent wants time for instructions on withdrawal of writ petition civil 16510 of 2015 filed by him. At his request, list on 4th May interim order to continue.
Because I start on this regulation 2018, my lord.
Whatever, sir, we'll hear all those arguments after you withdraw the writ petition.
Item 75.
May I please, your lordship? I am ready. Your lordship, kindly see the noting.
AD card has not come back.
My lord. Private OP number 6, my lord.
It's a fresh notice to respondent number 6, returnable. Ninth May. Tracking report we placed into court.
76.
My lord, the freedom fighter pension, my earlier petition was allowed. And against that order, the state went and appeal to the Supreme Court. The appeal to Supreme Court was dismissed. So I pray this dismissal order of this state government Supreme Court, it was not well interpreted neither by the state authorities nor the single judge. So I pray I will approach the finance department recommending authority to rehear my case, keeping in view the dismissal order of the Supreme Court.
Yes.
Counsel for the appellant has placed before the court order dated 2nd January 2013, passed by the Supreme Court of India, dismissing the SLP civil bracket CC 21778 of 2012 bracket filed by the state of Orissa against the order dated 28 June 2012 in interpretation civil 20707 of 2011. That view of the matter, learned counsel to the appellant seeks leave to withdraw the present appeal, with liberty to approach the state government. For grant of pension, is it?
My lord, my lord.
In light of the above order of the Supreme Court. Read with the order of the High Court, which has been affirmed. The appeal is disposed of, is withdrawn with liberty spread for.
Obliged.
Item number 77.
76 is password, man.
76. 76 is over.
76 is over. 76 is disposed of.
Right. 77.
77, I am appearing for respondent number 2 in the first case. I require some time. Any date, not on 16th January.
All right. Planetarium. Mr. Ashok Mantri, learned senior counsel appearing for respondent number 2, states that he is in some difficulty today. At his request, list on 8th May.
8th May. That will be nearer to the vacation for the. Can it be little bit earlier?
No, sir. Right.
Item 78.
May I please, Your
Yes.
Lordship, the impugn order is at page 79. This is the case, my lord. When subsequently his height was found to be less than the required height. Accordingly, they were removed from the panel list. And
all this we can't interfere with, sir.
And it is also squarely
the height is less than the required height.
The lordship kindly say it is squarely covered by my lord's judgment.
Yes.
The lordship has found that in that State of Odisha versus Subhanarayan Mishra case.
Right.
May
I may be given time to peruse your lordship time judgment.
We can't play around with these things. These are security forces, no? What is this?
Yes, ma'am.
CRPF?
Yes, ma'am.
Or CISF?
A copy of the judgment so that I.
That's right. Covered, sir.
My lordship, I should go through the same.
Counsel for the, Dr. Lenka, learned counsel for the respondent. Seeks time to study the judgment of this court dated 26 October 2021. Not reported, is it?
Not reported. That I'll show one document from their file that is sufficient, my lord. That they are saying there is no provision for remeasurement. If your lordship will see that one document, your lordship may see for a moment one document.
Anyway, he wants to study the time.
My lord.
Writ petition civil 6632 of 2019 bracket state of Odisha versus Subbanarayan Mishra. At his request list on first March.
I have given that judgment.
All right.
Item 79.
Item 79, I am for the petitioner, my lord. My senior is not feeling well, my lord, today. Kindly taken up next week, my lord.
Counsel, the apprentice stated to be unwell. Defects be removed before the next date. 4th May.
My lord, I am there on behalf of the respondents. My appearance will be much.
Item number 80.
Lordship, item 80, pass over, your lordship. I'm seeking a pass over.
Okay, come up right away, sir. All right, pass over.
Yes, lordship.
Supplemental list passed over matter item number 15.
15. None appears despite a pass over. Dismissed. Yes.
Item number 33.
Depreciation.
Yeah.
Depreciation. No, it's all right. So 10%, 25%.
The 2003-4. Today we are 20 years down the line. The asset has been written off, whether it is 15%, 3%, 100%, whatever. We are to fight our academic issues like this in the case of this. This is all. What is the question of law in this grade?
Yes, Mr. Chimanka.
Yeah, the first is item number 65. 65 is the only depreciation. 25%
or 10%.
And 10%. IT allow 10%. Question has been framed. At page number.
No, that question is not framed.
No, question has been framed.
When?
Only notice is issued.
No, only notice has been issued.
So question is that whether the learned IT is justified to allow depreciation at 25% on railway and rolling stock treating such fixed assets as plant and machinery. As against depreciation of 10% allowed by the AO in the implement assessment order treating same as building. This is only one question.
What is the, it is railway stock. This is railway siding, right?
Railway.
I have prepared a chart.
All right.
A number of years are there.
All right.
Which may help. 2 sets.
2 sets.
One by one. 48.
There are 3 and 4. All right. We'll decline to frame the questions. You see, the present appeal with revenue is directed against the order dated 11th April 2012 passed with Income Tax Appellate Tribunal, Cuttack, Bracket IT 18. dismissing the revenues appeal ITA number 437/CTK/2011 and 438/CTK/2011 for the assessment year 2004-5. Full stop. The question considered by the ITAT was whether the claim of the SSC for depreciation on railways and rolling stock at 25% was justified by treating it as part of single court's plant and machinery, unquote. Question mark. The assessing officer had allowed depreciation at 10% instead of 25% by treating it as single court's building, unquote. The ITAT has referred to the factual aspect in the case where the said assets served the special purpose of working and therefore ought to have been considered as single court's plant and machinery. Stop paragraph. Having heard learned counsel, Mr. Ishwar, senior counsel for the petitioner, and Mr. Chimanka, learned counsel for the of the SSC, and Mr. Chimanka, learned senior standing counsel for the department. This court is of the view that in the facts and circumstances narrated and noticed by the ITAT, the SSC was justified in claiming depreciation at 25% by treating railways and rolling stock as single court's plant and machinery. Unquote. Stop. Consequently, the court finds no reason to interfere with the impending order of the ITAT and declines to frame the question as urged by the revenue. The appeal is dismissed. 60%. So now 64 in view of the dismissal of ITA 65/2012 by an order passed today by this court. This appeal is also dismissed. So 64 and 65 is over.
Then 89.
Then
89.
89.
89 question frame. At page 3, the registration matter.
That's right. 12 capital A.
12A. Whether in the facts and circumstances of the case, the registration under section 12A allowed to an SSC means an automatic exemption from the charge of income tax of all types of income to SSC. Second, by resolution, whether in the fact profit and gains of an SSC can be considered to have been accumulated for the purpose of genuine charity without a valid resolution by the concerned trustee, members of a trust, or an association violation of Rule 17. Third is the important, whether the accounting infirmities and irregularities detected by competent authorities like Comptroller and Auditor General of India would not make the declaration filed by the SSC regarding correctness of the accounts for the purpose of claiming an exemption under section 121 of the IT Act. And last, whether in the amendment brought out the Finance Act 208 to the provision of section 215 of the IT Act can only be considered to be applicable for the assessment of 9-10 onwards and not to be applicable for any past assessment year. And E, whether the Honorable ITT can totally ignore the reasoning given by the first appellate authority on the various issues involved in the assessment order as per the grounds of appeal taken by the SSC, and instead of simply base its conclusion as per the argument and submission of the appellant without justifying as to why the reasoning given by the first appellate authority in the facts and circumstances of the case were unjust, were totally incorrect. Then F, whether in the case of the trust AOP institution claiming to be engaged in charitable activities for the purpose of computation of its net income, utilization of the income for charitable purpose, accumulation of unutilized income for future charitable purpose, it is necessary to draw the receipt and expenses account of such entities, organization, trust on cash payment of accounting and none on the basis of accrual. Then it is wrong. Whether absolutely similar activities carried out by the Port Trust right from 1963 can be lawfully considered as charitable till the assessment at 2089 and not charitable from assessment at 910. Criminal order is there.
So basically, they followed the earlier on the first issue. They followed the earlier years.
That is ITA 48.
48.
Or 7, 8.
48.
ITA 48. That is the earlier order.
All right.
2007-8.
Okay.
And question has been framed at page number 9. Whether in the facts and circumstances of the case, registration under section 12A allowed to an SSC means an automatic exemption from the charge of income tax of all type of income tax of the SSC. Same question. Whether on the profit and gain of the SSC can be considered to have been accumulated for the purpose of genuine charity without a valid resolution by concerned trustee members.
Same.
Same.
All the questions are the same.
Same.
Yes, tell us. Why should we interfere?
They are gone through the appeal order. 12A was applied and rejected by the CIT on 29/9/06. And ITO order 6508 directed to grant RC under section 12A and CIT grant registration by order dated 27/7/08 with effect on 1405. And this is related to assessment to 2078. See explanation of section 1020 in 2034. Rotate. Yeah. Page 14, running pad. However, subsequently it is applied for registration under section 12A as a charitable institution. This application rejected by the CIT by the order dated 29/9/06. However, the SSC moved before the tribunal and tribunal by the order dated 6508 has directed the CIT to grant registration under section 12A of the Act. Accordingly, the CIT passed the order under section 12A granting registration to the SSC by his order dated 24/7/08 with effect from 1405. And this is related to assessment of 7/8.
So once it's granted from 1405 itself, then why should it not apply here? Can you tell us this 12A point?
They have raised this question, which doesn't at all arise from the order of the tribunal.
Oh, I see.
But they say that the registration under 12A of the Act, of the Income Tax Act, will not grant you automatic exemption. I have not claimed that.
Oh, I see.
I still went under section 11.
Okay.
12A is separate proceedings.
Right.
Thereafter, I must get registration, then file my return.
Right.
And I have filed the returns. They have examined every claim.
Right.
And they have held that 11 is applicable. They followed 2007-8. That is also before your lordship. So this question is a wholly academic exercise. Nobody has claimed
automatic
exemption.
Okay.
I can't. I have no legs to stand.
All right.
12A doesn't give me a blanket exemption. I still have to file a return.
Right.
Go before the officer, demonstrate that the income has been applied. There's no violation of 13 and all that.
Right.
The tribunal has only said that. Nowhere we find a mention
that you're automatically entitled.
Yes.
All right. And then what about the second one? Valid resolution? For profit and gains,
yes,
there has to be a valid resolution.
There is a rule. There is a section says that if I am not able to apply 85% during this year for charitable purposes, I can go for accumulation. I can apply by giving notice to the income tax officer that please allow me to accumulate the income.
Like a carry forward.
Earlier it was I could carry forward for 10 years. Now it is restricted to 5 years. At that time it was 10 years. Now I have to give a notice. And there is a rule 17, which says you must give a notice to the income tax officer. I gave a notice. The notice was has to be in the prescribed form number 10 of the income tax rules. Now, in the income tax rules, the form, neither the act nor the rules say that you should file the valid resolution of the board. All you have to do is to give a notice to the officer. We gave a notice. Now they are latching on to the form number 10, where there is a reference that it should be by a resolution has to be produced. But the only submission was that this is a form which cannot overreach either the rule or the act. And nobody denies that I have given the income tax officer relevant.
Disentitle you to carry forward only because you did not have a valid
that is all. Your lordships may see the form 10. Form 10 for the first time.
It's there in this compilation.
Yes, that's at page 6. Where does it say that resolution? It says, I on behalf of so and so hereby bring to your notice that it has been decided by a resolution passed by the trustees. This is all. I have said that, file this form. Rule 17, which also has been enclosed. Rule 17 of the income tax rules only says the option to be exercised in accordance with the provisions of the explanation to subsection 1 of section 11 in respect of income of any previous year relevant to the assessment year beginning on or after so and so shall be in such and such form and shall be furnished before the expiry of the time allowed under section 139(1) for furnishing the return. I have given that. That is accepted. They have invented a new point saying that where is the resolution? I have only to state that I have, by a valid resolution, the board has decided to accumulate the income. This is all the submission. The tribunal has said there is a compliance of the section and the rule.
Right. Because otherwise, even the form would normally say enclosure. And if it has to be enclosed, the form would say that there has to be an enclosure.
Yes.
Because once you make a declaration, it's a resolution. It doesn't require you to enclose it, right? All right. We can ask for it. Yeah. Right.
Statement should be signed by a trustee, delete them. That's all it says.
All right.
The second is the money so accumulated or set apart is invested or deposited in the form or mode specified in the subsection 5. They have to be 2AB, 11 2AB.
11 sub 5. The trust is obliged, is bound to invest all its funds in approved securities only. That's a different point, entirely different point. 11.5. If I violate that, I lose my exemption.
All right. Then the third one is accounting infirmities pointed out by the CAG.
What has happened in the statement filed along with my return, the officer found that you have overstated your assets and understated your liabilities, which only means that I have offered more income than what was actually to be offered.
Right.
He says this is contrary to the CAG's report and all that. All I am submitting, and the tribunal has accepted, is that he has been overassessed. In fact, the assessee should object to that. But the assessee has not objected to that. He only says that you have been overassessed.
So actually, it should work to your benefit. All right. I think the fourth one is obvious. It can only be prospective. This kind of an amendment.
Finance Act itself says so.
All right.
I have placed the Finance Act also.
All right.
It says it comes into effect from 1/4/2009.
Right.
It is at the very first.
Yeah. Correct. Correct.
The following clause shall be substituted with effect from the first day of April 2009. The Lordships gets that?
Yes.
Section 3,
yes.
Clause B, at page 5. At page 5, the compilation.
Right.
For Clause 15, the following clause shall be substituted with effect from the first day of April 2009.
Correct.
So it applies from 9-10 assessment year.
Correct. Then this accrual basis, cash basis for that 0.6 in this chart. Cash basis of accounting instead of accrual.
Yes, this was, they never raised this point at anywhere in the.
Oh, they're raising it for the first time. All right.
Page 29. But I have either to follow cash system or to follow the accrual system. Either way, my income, I have to spend 85% of my income on charitable activities in India. If I don't, I can accumulate. But whether I follow cash system or mercantile, and Paradip Port Trust is a company registered under the Companies Act. It has to follow the accrual. There is a mercantile system. There's no option. It cannot follow cash system.
Right.
I have covered this in the counter at paragraph 33. File button. Respondent humbly submits that the proposed question of law does not arise out of the order of the tribunal, etc. When there is no decision on this aspect of the case, the question proposed is merely academic, cannot be referred having regard to the scope of 260. In Scindia's team, it was inter alia held by the Supreme Court that a question which was neither raised before the tribunal nor considered will not be a question arising out of the order of the tribunal, notwithstanding that it may arise on the findings rendered by it. In the present case, issue whether the receipts and expenses account of the respondent trust has to be drawn upon cash or accrual system of accounting was never raised by the appellant before the tribunal. Appellant is department.
Right.
Nor has the tribunal rendered any finding there. Tribunal has relied upon its own order, etc. Therefore, this court may be pleased. This is what. This is an academic question.
Correct. All right.
Question 7. Your Lordship will see it is whether absolutely similar activities carried on by the PPT right from 1963 can be lawfully considered as charitable till assessment year 2008-9 and not charitable from assessment year 2009-10. They are questioning their own Finance Act. The question is completely misconceived.
Correct. And cash accrual you already gave answer. All right.
Then question number 9, whether once there is a finding of fact by the first appellate authority on the basis of written submission by the appellant that he has withdrawn the ground of appeal regarding chargeability of tax and interest on bank deposit on accrual basis, the SSC has at liberty to aggregate the same issue on a further appellate proceeding for the ITT. Question number 9. 9 and 10. Whether London Tribunal was justified to totally ignore the finding of facts recorded by first appellate authority regarding SSC withdrawing the point of dispute in respect of chargeability.
But they have shown it in their income. Interest income. Yeah, they've disclosed it in the balance sheet. There's no diversion, they say.
That we have to verify from the balance sheet mercantile system or accrual system.
This question of withdrawal is completely incorrect because I questioned this addition of 42 crores before the CAT appeals. CAT appeals confirmed the addition. Then I went to the tribunal. Tribunal held in my favor, saying that this is diverted by overriding title. It doesn't belong to you. So that is, so it is not as if I withdrew and then later on I resiled my position and took it up.
Okay.
I contested the matter. CAT appeals even confirmed the addition. Then I went to the tribunal. I have explained this in paragraph 37 of the counter filed in ITA 48.
Correct. Recorded the contention against the addition.
ITA 48 in
and eventually upheld it on merits.
Yes.
Right.
So the question of withdrawal and all doesn't arise here.
All right.
CAT appeals has gone into the merits, held against me.
All right. So this takes care of 48, 89.
Yes. Yes. 48 and 89. Yes. That is assessment year 7, 8 and 8, 9.
Now we still have, we have done 64, 65, correct? 48 and 89. So we'll have to still deal with 24, 34 of 2018, 90 of 2017, 1 of 2018. So we'll do it after lunch.
Yes.
All right.
Grateful.
No, so I think we'll dictate the other two, the two appeals now. 48 and 89. On IT 48 of 2011 and 89 of 2011. These two appeals by the revenue raise similar questions of law, but for different assessment years, bracket A wise, involving the same assessee. and are accordingly be disposed of by this common order. ITA 48 of 2011 is directed against an order dated 20th May 2011, passed by the ITAT Cuttack Bench Cuttack. In ITA 99/CTK 2011 and ITA 114/CTK of 2011 for the assessment year 2007-8 and ITA 89 of 2017 is directed against an order dated 9th August 2017 of the ITAT. In ITA numbers 395/CTK/2012 for the AY 2008-9. In both these appeals, common questions have been urged for consideration by this court by the review. The first relates to the registration granted to the SSC under Section 12 Capital A of the Income Tax Act 1961 Bracket Act.
This is not.
The question urges whether such registration allows the SSC automatic exemption from income tax on all types of income. Question mark. It is pointed out by Mr. Ishwal and a senior counsel again for the SSC that said question in fact does not arise from the impugned orders of the ITAT at all, since for neither of the AYs did the SSC actually claim automatic exemption on the basis of the registration granted in its favor under Section 12A of the Act. The court finds that the SSC filed returns and provided the justification for claiming exemption on a case-to-case basis. In other words, there was no claim for automatic exemption from income tax on the basis of the registration under Section 12 Capital A of the Act. Consequently, the court declines to frame such a question for consideration. Paragraph. The next issue raised is whether exemption could have been allowed. Whether there ought to have been a valid resolution of the SSC trust in terms of Rule 17 of the Income Tax Rules 1962. Right with Section 11 of the Act. Here the court finds that compilation section 11. In terms of Rule 17, the SSC is required to submit a statement in form number 10 to the assessing officer, which contains the statement that, open quotation, it has been decided by a resolution passed by the trustees of the governing body, ... unquote, that, open quotation, out of the income of the trust oblique institution association for the previous year, % of income of the trust institution association for the said previous year shall be accumulated or set apart for carrying out the purposes of the trust association institution. What's the unquote? The statement then sets out the details of the amounts so set apart. Paragraph. Mr. Chimanka, learned senior standing counsel for the revenue, submits that inasmuch as a copy of the resolution of the SSC trust was not furnished, comma, the above statement regarding amount being accumulated for the purposes of charitable activities cannot be acted upon. Paragraph. Perusal of form number 10 reveals that the requirement of the resolution, referred to in the statement therein, having to be enclosed with the form has not been indicated. Full stop. In other words, there is nothing in either section 11(2) of the Act or rule 17(2) of the rules that mandates the furnishing of such a resolution by the SSC in order for the statement to be acted upon by the assessing officer. Full stop. Consequently, the revenue cannot insist that without an actual copy of the resolution being furnished, the statement furnished by the SSC cannot be acted upon. Full stop. The court therefore concurs with the view expressed by the ITAT in the impugned order and declines to frame a question in this regard. Paragraph. The third issue sought to be urged is whether the declaration filed by the SSC regarding correctness of its accounts for the purposes of claiming exemption under section 11 of the Act ought not to have been accepted in view of the accounting irregularities pointed out by the CAG. Question mark. As pointed out by Mr. Ishwar, the report of the CAG indicates that the SSC has offered excess income for assessment, and therefore there cannot be any prejudice caused to the revenue whatsoever on this score. Full stop. It is not as if the SSC has gained any unfair advantage in the process. Consequently, the court declines to frame the question as urged. Paragraph. It is then sought to be contended that the amendment made to the Act by the Finance Act 2000 to section 2(15) of the Act by the Finance Act 2008 should be considered to be retrospective. Paragraph. The very text of the Finance Act 2008, and in particular section 3 thereof, which inserts the amended section 2(15), clearly states that, open quotation, the following clause shall be substituted with effect from the first day of April 2009, unquote. Full stop. Clearly, therefore, the amendment is only prospective. Full stop. Consequently, the court declines to frame this question either. Paragraph. on the issue whether the SSC ought to have resorted to the cash system of accounting and not the accrual basis. Well, it has been pointed out on behalf of the SSC that it is bound by the guidance note of the Ministry of Shipping and Transport, Government of India, and the requirement of the Companies Act as regards maintaining its accounts on accrual basis. Full stop. Consequently, this court finds no ground for taking a view different from what the ITAT has taken in the matter. Full stop. Paragraph. It is ought to be contended on behalf of the revenue that
it is rather difficult to understand this question. Because it doesn't appear to make any have any relevance to
that's right. That's right.
So from the date of the amendment, the proviso was added. That's a different question. But they have not invoked the proviso in this case at all.
Right. Right.
It appears to be a completely academic.
See, it is next thought to be urged that the SSC had withdrawn ground urged by it before the CIT bracket A regarding taxability of interest on two funds, F capital. Full stop. A perusal of the order of the CITA shows that, in fact, the SSC had maintained its contention against the addition of the additions made by the AO in this regard, and the CITA upheld the addition. Full stop. Therefore, the question appears to be misconceived. And therefore the court and the court accordingly declines to frame the question. Paragraph. In ITA 89 of 2012, an additional question is sought to be raised whether absolutely similar activities carried on by PPT from 1963, considered as charitable to AY till AY 2008-09, will cease to be charitable from AY 2009-910. Question mark. As pointed out by the SSC, the change occurred as a result of the prospective amendment to section 2(15) of the Act, the validity of which obviously cannot be questioned by the revenue. Full stop. Consequently, this question also does not arise for consideration. Paragraph. For all of the aforementioned reasons, the court declines to frame any of the questions urged by the revenue in these two appeals. They are accordingly dismissed. So now we turn to which one? Mr. Chimanka?
89, 3 identical matters are there.
Sorry?
3 identical matters are there.
No, this 90 of 2017, 34 of 2018, 24, they're all identical.
No, 90, 34, and 156. ITA 48.
48 and 89 same.
48 and 89 if taken together.
Same.
Right.
Dual registration.
Lordship may take 90, which is assessment year 2009-10. Yes. But here,
depreciation plus pension fund.
It's all about contribution to the pension fund. The approval was given right from the date of application. It has to be approved by the Commissioner of Income Tax. These funds. Approval was given from the date of application made for approval. But there were certain payments made even prior to the application as a welfare measure. But what the tribunal did was, after all, this is a welfare measure. It has been subsequently approved.
Like a ratification.
They said there's no need to be so technical. Funds have gone out, it has reached the fund, and the fund stands approved, though from a slightly later date. So on that basis, they
then interest accrued on investment on capital assets.
That will be later.
57 crores.
That will be next. That will be unconnected with this. The first two are on the same basis.
All right.
Both are payments made prior to the date of approval of the fund, but still allowed as a welfare measure because it has gone out of the PPT's funds.
Right. Then the next was interest accrued.
What has happened is, under section 90 of the Major Ports Act, the government has got the power to direct the Paradip Port Trust to set apart certain funds and deposit them in the bank accounts.
Right.
And these funds are to be used only for the purposes which are stated in the section.
Right.
And the directions were issued by I have placed those copies, by the government, Ministry of Shipping, to the Port Trust, directing these amounts to be put in those funds. Whether the interest, because those funds are to be deposited in the bank account, and some interest is accrues to them. Now, what the trust does, the assessee does is, it claims that since the fund cannot be touched by me, except for the stated purposes and as per the government directions.
It's not like a revenue.
It is not under my control. So the interest, which is only an adjunct to the principal amount, also was taken directly to the balance sheet instead of routing it through the profit and loss account. It was taken directly to the balance sheet. And they claimed that the interest is not taxable because it's diverted at source by overriding title. That's the principle they have claimed.
Right.
And the tribunal has accepted that,
that,
saying that because of the government's orders.
Right.
And
right.
In my counter, page 37, it is counter filed in ITA 90. I have referred to those government orders also.
All right. All right.
And that is the basis on which they say this is not the trust's income.
Okay. Okay.
And these are settled by the series of decisions. Your lordships may recollect, molasses fund cases are there, where sugar mills were directed by government order to deposit a particular amount out of their sales.
Levy sugar. They will say.
And that fund is to be used only for the purpose of building molasses storage tanks and no other purpose.
Right.
Whether the interest which represents an adjunct to the fund, whether it can be taxed, that was a question which came up. They said it cannot be taxed because it is tied up to a particular fund and you have to use it only for that
purpose. Okay.
You don't have control. But I have cited all those cases in my counter.
All right.
And the paragraph reference also is given at the last column.
All right. That is as far as interest.
Yes. Then depreciation on railways, your lordship.
That's already covered.
Yes.
All right. So these are the only 4 questions. All right. This ITA 90 of 2017. This is revenues appeal against an order dated 9th August 2017 of the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80, dismissing the revenues appeal ITA number 395 oblique CTK. No, 356 oblique CTK oblique 2013 for the assessment year 2009-10. Paragraph. The first question sought to be urged by the revenue is whether the first 2 questions sought to be urged by the revenue is whether the IT80 was justified in deleting addition of 25 crores under the single quotes provision for pension fund unquote and deleting the addition of rupees 20,86,903 under the head single quotes employers contribution to provident fund unquote, the approval for which was not granted at the time when the contributions were made. Question mark. The fact of the matter is that the CIT recognized the PPT Employees Pension Fund Trust by an order dated 25th March 2010 with retrospective effect from the date of its creation, that is 3rd February 2009. Full stop. The contribution was made on 7th May 2008. But at no time an objection was raised with revenue that it does not constitute business expenditure. Full stop. The CIT bracket A accepted the plea of the SSC that the delay on the part of the CIT in granting recognition should not prejudice the case of the SSC. Full stop. This View has been upheld by the ITAT. Full stop. As long as the contributions made have been towards the fund, with only the approval being granted at a subsequent stage, should not deprive the assessee of the benefit thereunder. Full stop. Consequently, the court declines to frame any questions on as regards the deletion of these two additions. Paragraph. As regards the addition of rupees 57 crores, deletion of the addition of rupees 57 crores under the head of single quotes, interest accrued on investment on capital asset, replacement reserve fund and development, repayment of loan and contingencies reserve fund, it is pointed out that the SSC has two statutory reserve funds, namely one, replacement, rehabilitation, modernization of capital assets reserve, and two, reserve for development, repayment of loans and contingencies. Full stop. These reserve funds had to be established in terms of section 90(1) of the Major Port Trusts Act and the directions of the Ministry of Shipping and Transport. Full stop. The central government is stated to have fixed an annual ceiling of the reserve at 3% of the capital employed in respect of each of the funds. Full stop. Therefore, there is a mandatory requirement that interest should follow the funds so created. And since it is and it is directly therefore taken to the balance sheet and not shown in the profit and loss account. Full stop. Once there is a diversion at source, as a result of there being a statutory obligation on the SSC to set aside a certain sum, the SSC was justified in not showing the interest income in its P&L account and taking it directly to the balance sheet. Full stop. The view taken by the CIT as approved by the ITAT is consistent with the decisions in CIT versus Sheetal Das, Tirat Das, 1961, 41 ITR 367 (SC). And several decisions of the High Courts, including DCM Limited versus CIT, 2004, 192 CTR Delhi, 408, and Somaya Organochemicals Limited versus CIT, 1995, 216 ITR, 291, Bombay. Consequently, the court declines to frame a question on this issue as well. Paragraph. The last question urged concerns claiming depreciation on railways and rolling stock, which has already been answered in favor of the SSC and against the department by an order passed today by this court in ITA numbers 64 and 65 2012. Paragraph. For the aforementioned reasons, the appeal is dismissed. So 90 is done.
34. Assessment year 10-11. The questions are the same. The first question is about that pension fund contribution.
Right. So it's covered by the
assessment year 10-11. That is already decided in the earlier year, Your Lordship, sir.
Right.
Then the second one is the interest which is diverted
That's
by
also
operating
answered.
title. The third one is the depreciation of the rolling stock.
Same thing. All right.
Same. These are the three.
All right. In ITP, but the revenue is directed against the order dated 24th October 2017 of the Income Tax Appellate Tribunal, dismissing the revenues appeal ITA number 121/CTK/2013 for the assessment year 2010-11. Paragraph. 3 questions are sought to be urged by the review for consideration by this court. Of the first question regarding deletion of an addition on account of unpaid amount of provisions of the pension fund has been answered in favor of the assessee and against the review by a separate order passed with this court today in ITA 90 of 2017 filed by the revenue. Paragraph. The second question regarding deletion of an addition made under the head interest accrued on investment also stands answered by the order passed by this court against the revenue in ITA 90 of 2017. Paragraph. The third question regarding depreciation on railways and rolling stock has already stands answered against the revenue by the order passed by this court today in ITA 64 and 65 2012. Consequently, the present appeal is dismissed. 156 of 2018.
In between, there is one 24. ITA 24.
24 is only depreciation.
Only one issue. There is depreciation. Assessment year
24, is it?
24. ITA 24.
11,
ITA 24 of 2018. You see, in view of the order passed today by this court in ITA 64 of 2012, the present appeal, which raises only one issue, which already stands answered in the said order against review, is also answered likewise. This appeal, which pertains to AY 2011-12, is accordingly dismissed. Now 156.
156. The first question is only peculiar for this year. Question of unascertained liabilities.
All right.
What was pointed out was that there are certain claims made by the assessee in the return, which the assessing officer took the view that they are not ascertained liabilities and therefore they cannot be allowed. In the assessment year 2009-10, also a similar disallowance was made. Against that, the assessee went in appeal in that year and tried to demonstrate that these are not unascertained liabilities, these are already accrued liabilities. I have received a demand for these amounts. CET appeals called for a remand report from the assessing officer because these were all fresh evidence. Assessing officer on remand accepted the claim that these are all ascertained liabilities. 2011-12, no question has been raised by the department, even though the tribunal allowed this on the same reasoning.
So consistency then.
Consistency. For this year alone, they're raising the same thing.
All right. All right.
And the second question is about the investment in the interest from the two investments. Third question is about depreciation.
All right. You say 156 of 2018. This is an appeal by the revenue against an order dated 27th April 2018 passed by the ITAT. In dismissing the revenues appeal, ITA number 256/CTK/2016 for the assessment year 2012-13. Paragraph. The first question sought to be urged by the revenue concerns the CIT bracket A allowing single quotes unascertained liabilities unquote claimed by the SSC on account of accrued expenses question mark. It is pointed out by Mr. Ishwal and a senior counsel for the SSC that in the earlier AY 2011-12, a similar claim had been allowed in favor of the SSC by the CITA after receiving a remand report from the
910. That is for 910. That is for 910.
Oh, from the earlier year AY 910, 2009-10. The CITA had allowed a similar claim of the SSC after calling for a remand report from the assessing officer, bracket AO. Full stop. It is pointed out that the AO, in fact, in the remand report, confirmed that what was being claimed was, in fact, single quotes, ascertained liabilities, unquote. It is pointed out that even in the subsequent AY 11-12, a similar issue arose, which was not carried in appeal.
It was carried in appeal to the tribunal, but here no question of law has been raised on that issue.
All right, which was carried in appeal to the tribunal by the revenue. But before this court, no such issue was raised in the appeal filed by the revenue. Full stop. Following the rule of consistency, therefore, the court declines to frame the question for the AY in question. Paragraph. The second issue raised pertains to deletion of an addition made on account of interest earned on two reserve funds. This issue has already been answered by this court today in a separate order passed in ITA number 90 of 2017. And accordingly, the court declines to frame the question. Paragraph. The third question pertains to depreciation on railways and rolling stock. We'll stop in view of the order passed today by this court, separately in ITA 64 of 2012, answering the question against the revenue. The court declines to frame the question. Accordingly, ITA 156 of 2018 is dismissed.
Yeah, grateful. I'm sorry I was not here when the case was.
No, it's all right.
My flight got delayed.
Okay.
Grateful.
Pastor matter item number 80.
Item number 80.
Your Lordship, I appear for the petitioner in item number 80.
Yeah.
They have not carried out the amendment, nor consolidated copy available with your Lordship, nor served on us.
May I submit, Your Lordship? An IA was filed with the consent of the parties. It was agreed that in place of the earlier bank, the name of the new bank would be substituted and there would be no other change in the pleadings. Everything else has been supplied to the counsel for the bank. And Your Lordship,
nothing.
From the order sheet of this case, that or one or the other ground, the entire effort is that the matter is somehow not heard. There is no change apart from adding two respondents in the memo of parties. No other change.
No, but Mr. Garia, last time we recorded that you'll be filing an application. That's why he's saying this.
No, but there is an order of Your Lordship that these two parties, 9 and 10, are to be added, and they have been added. They sought time to seek instructions whether these are the parties which should be added. They sought instructions, the court allowed with the consent of both the parties, addition of the parties. Nothing remained after that.
Your Lordship, kindly see Your Lordship brief.
No, there is an order. Just see this IA 1797, an order is 28 September 2021.
That is, Millard, that this case was allowed. There is no dispute about it. He has to carry out the amendment. That's why office note shows that he has not carried out amendment, copy not served on us. He has to serve the consent, amended copy.
Two parties are pleaded separately.
How can I appear?
Only at best, the parties are named. At best, what would be absent in the file is a separate memo of parties. There is no change in the petition.
I have to file wakalatnama.
And Your Lordship will see from the order sheet that several times this issue has never been raised. For the last several dates, all what has been said is sometimes personal difficulty, sometimes other difficulty, and the matter is not heard. The matter has not been allowed to be heard. So, and case involves a short issue, Lordship. The only issue involved in the case is that the bank says that they have passed an internal circular by which they have introduced a requirement for having 35% minimum marks. My case is, Your Lordship, that the bank circular itself says that they are that the directions issued by the government of India are binding on them, and the instructions issued, guidelines issued by the government of India as to how promotions have to be carried out does not contain any prescription for minimum marks in interview. My difficulty is that in all these years, 2016, 2017, 2018, bank in its counter affidavit states that despite the bank not giving me even 35% marks in interview, my total marks are more than the minimum cutoff. There is no dispute that I have obtained marks more than the minimum cutoff. The only dispute is they say we have
merit, let him submit.
Over cutoff.
He has appeared 3 times on the basis of same notice. He was not selected. Not only he, about 138% above him also not selected in 2016. And the same circles, eyes open, he has appeared and not selected. Thereafter, he cannot agitate that point. That I will submit. But let him now carry out the amendment, that copy be served. I will appear on 9 and 10. They are the Union Bank Miller, that is emerged. I was appearing for Andhra Bank. So my learned friend is making submission, which is not, let him submit place the judgment Miller. The judgment is very clear, elaborately dealt with all the points he has raised.
Your Lordship,
let him place the judgment.
Your Lordship,
let a date be fixed. Let him place the judgment. Then let my friend argue the matter.
Your Lordship, Your Lordship will
no, it is not
the entire point in this case was, can bank issue a circular contrary to the binding government guidelines which do not prescribe for minimum marks in interview?
No. So the point, Mr. Gadia, the point that Mr. Rao is making is a slightly different point.
Yes, Your Lordship.
This is the point that once you participate in a selection, you can't turn around and question the rules governing the selection.
Not only 1 year, 3 years.
Till I filed an RTI. After I got to know that I was not selected only because I did not get minimum marks in interview for 3 years during the pendency of this petition, not earlier. And Your Lordship will notice that even the advertisement issued in 2016, 17, 18
was silent on this.
Any stipulation
I see.
Saying that minimum marks in interview have to be obtained.
But he says even persons who had got cumulative marks higher than you were not selected.
Yes, that is definitely the judgment.
Select 1,000%, they may not choose to challenge. But advertisement does not say minimum marks for interview.
What is this promotional post, sir? What is this post, promotional post?
This is managerial scale 2 to 3. Managerial scale 2 to 3. The petitioner was a legal manager in the bank. And not only he was not selected, but because he chose to file this petition, I may submit, this is my understanding, that because I challenge the policy on the bank that they can pick and choose anyone by choosing not to give minimum marks in interview, because I challenge this policy, I have now even been terminated from service. The disciplinary inquiry was instituted, I have been terminated.
Now,
that matter is also pending before this honorable court.
No, but unless that is decided, what's the point in deciding this?
Your Lordship, because
you better get back. You have to climb. You have to get back into the train.
No,
Your Lordship. Then we will know that whether you should be in 3-tier AC or 2-tier AC. But you're not in the train at all now.
These years, I will at least get some money.
No, only if you are in the train. Only if you are in the train. First, you get back into the train.
No. For the period before termination, I will be entitled to some benefits.
We don't know that.
No, if I am successful here. So this is an independent cause of action, at least to that.
No. It is certainly independent cause of action. There's no doubt. But if you're not even an employee of the bank anymore,
yes, Your Lordship.
Till you again, your employment is restored, then all this will become academic.
No, Your Lordship, in 2020, and I was removed from service from 2016 to 20, the difference between the pay scales, at least I will be entitled to that.
No.
So, and here the issue is short, Your Lordship.
Issue may be short. No, the issue may be short, but the question really is, your challenge to your termination is pending before the single judge.
Your Lordship.
So let that get decided.
Your
Let that decided. This appeal is not going away anywhere. It's a 2020 appeal.
Your Lordship.
Your
Lordship,
so let it remain.
That also, here both these matters together in that event, Your Lordship.
No. One is division by. Why should you deprive yourself of a right of appeal if it goes against you, or them if it goes against them?
Because Your Lordship is a young man. If either way, if he succeeds or is unsuccessful, there will be some clarity in his life. So it is interest to forego. I have categorical instructions in this regard that I have instructions to forego the right to appeal, and that petition may also be called for in a date.
No. Bank may want to appeal. If you succeed, they may be deprived of a right of appeal. So
Your Lordship, but so therefore let it be there where it is. But in this case, because the only issue is
you regularize
when bank relies on a circular. Bank relies on a circular. And the opening lines of the circular are that the guidelines issued by the government are binding on us. These are the opening lines of the circular that the bank seeks to rely. And these guidelines do not provide for minimum marks in interview. Advertisement does not provide for minimum marks in interview. So, and this issue that what will be the effect of the circular saying government guidelines are binding and the government guidelines not prescribing for minimum marks in interview has not at all been considered by the Honorable Single Judge. Not at all been considered. Honorable Single Judge has simply said, because there is a circular of the bank, we won't see anything else, and the petitions are dismissed. Despite all these things there being on record, despite all these pleas having been raised before the Honorable Single Judge. So this is Your Lordship. If I can point out the circular relied upon by the bank, this is the circular that they say.
No, but first let's get the technical things out of the way. You say that IA 1797 of 2021, for the reasons stated therein, the application is allowed. And Union Bank of India, through its two representatives, are substituted in place of opposite parties 9 and 10 in the memo of writ appeal. As per the schedule to the present application. Then in the main writ appeal, you say Mr. Rao states that he will now be appearing on behalf of the newly substituted Union Bank of India, respondents 9 and 10. Stop. Paragraph. Mr. Gadia states that he will file a written note of his arguments within 2 weeks with an advance copy to Mr. Rao, who is permitted to file a reply note of written arguments before the next date. When is that writ petition, the other one listed, or no date is given?
Your Lordship,
that is single judge assignment, single judgment.
No, when is it coming up?
Your Lordship.
There's no date in that.
No, I have appeared there. There also, Millard, that is sexual harassment in the workplace.
No, but where is the date of that?
No, I have not.
Your Lordship,
let him, Millard, let your Lordship regularize, let your Lordship fix a date. Let him place the judgment of the single judge.
You've asked him to file a written note, sir. I've asked him to file a written note. I've permitted you to file a written note.
Millard.
All right.
Judgment is very clear. He has raised all the points, argued at length.
Fourth May.
Let him serve also a copy of that amended cause title. Millard.
No need for all that, sir. It's there in the order.
Not your Lordship brief also not corrected. Your Lordship brief also part is not added.
Now it will be added, sir.
Yes.
All right.
Let him give consolidated cause title.
The consolidated cause title will be filed within a minute. All right.
Most obliged.
All right.
Your Lordship, could I request for an earlier date if at all?
No. Let it come. Let it come. All right.
Most obliged.
Weekly list. Item number 129.
129, is it?
129.
All right. None appears dismissed. Both.
Item number 131.
My lord, in 131, my London senior Mr. Rath is out of station. He made a mention even yesterday.
Correct. It will stay on board. All right.
Item 132.
Your Lordship, item 132, no instruction of this.
No instructions dismissed. All right.
Item 133.
Lordship, no instruction.
No instructions dismissed.
Item 134.
None appears dismissed.
Item number 135.
May I please, Your Lordship? My Lordship, the file has been transferred today to me, and I have also not prepared it well. And
Will stay on board. Okay.
Okay, my lord.
Monday.
Item 136.
May I please, Lord? My lord, brief has been transferred from us.
All right. Counsel, the petitioner states that they do not have the brief any longer. Dismissal on prosecution. Okay. Entry modification.
Item 137.
None appears dismissed. Same. Both matters. Three matters.
Three matters. Item 138.
None appears dismissed.
Item number 139.
The petitioner is a lazy under the ITCO, my lord. Petitioner is challenging the imposition of damages to the tune of 13 lakhs some odd.
It's a money suit you have to file, sir.
No, my lord, Lordship, there is no deviation because Lordship may kindly have a glance. I was allotted a plot of land in the year 2002, my lord. It was handed over in 2004. I was not able to use the plot because there was no electricity connection to the plant, to the site, my lord. And basis on that basis, they issued a so-called that for non-utilization of the land, they imposed these damages, my lord.
Right. That's part of the clause.
No, my lord. Lordship may kindly have a glance at what they say in the counter is that it's on the basis of clause 17 of the lease. I have annexed the lease.
My lord, that has been clarified. That is typographical error. That is clause 20 that they have annexed in rejoinder affidavit. On the basis of clause 20 of the lease agreement, they have to pay the damages. Accordingly, my lord, that on the basis of ITCO norms, they have to pay.
No. I was not able to use electricity to the land. It was disconnected because the prior lessee who was using the land had some areas upon it, my lord. For that, they gave electricity was initially installed. Thereafter, after 2 days only, the electricity has been disconnected. I have annexed those documents, my lord.
131. That's okay, sir. That's your responsibility.
My responsibility for paying the areas of the
early. Then you can sue him to recover that.
There is no such clause under the lease, my lord. Lordship may kindly, I have annexed the lease.
There is a clause which says if you do not construct, you will have to pay damages.
But without electricity connection, how can after 4 years?
Give up the lease, sir. Then give it up. That's all. These are all contractual matters. That's why it should not be, first of all, projected in a writ petition at all. But if he insists, we'll have to decide it. Where is your, you've clarified where in the counter affidavit? My lord, sir. Copy the lease deed, annexion 27. My lord.
That I have annexed.
That only para 17, that is para 20 of the lease deed, that is typographical error, that my lord, we consider. In page 3 of the counter affidavit. In the event of cancellation of allotment, that one, my lord. In rejoinder, my lords may kindly refer to, that is at page 18, my lords. Right. Clause 20 in the event of cancellation of the allotment. Correct. That is.
All right. They are relying upon a board of director resolution which is of 2014. My lease is of 2002, my lord. I was a lessee under them since 2002.
Right.
And what they are relying upon, what they have annexed in the counter, my lord, it's of 2014, a board of director resolution which I was never served upon or I am not aware upon, my lord.
Yes.
The counter which they have annexed those documents, it's of 2014, my lord. I am a lessee under them since 2004, my lord.
My lord, IDCO Act is 1980. That power flows under section 4 of the IDCO Act. It consists, corporation consists of board of directors, my lords.
So board of directors accordingly time to time they used to amend the circulars in the interest of corporation. That is there if Manoj may refer to also the section 4 of the.
No, when was this lease cancelled?
That has been
2008.
cancelled. Show cause was
2008.
issued and 2008 because of.
This 500 rupees per day is fixed when?
Pardon, my lords?
No. In case of this charging 500 rupees per acre per day.
That is, we have annexed, my lord, that page 6 of the counter affidavit.
No, that is dated 24/10/2014.
My lord, again the petitioner applied for change of activity after cancellation of the allotment in during the year 2014. So considering his application upon detailed deliberation, IDCO accepted his proposal, but subject to the payment of damages and.
That's right. The rate of damages. Was fixed for the first time only in 2014.
Circular came in 2014.
No. But if the cancellation took place in 2008 itself,
my lord,
how can you apply this norm to? This is prospective, right? What were the damages at the time the cancellation took place of the lease?
My lords, the circular came into force with immediate effect, my lords.
That's right, in 2014.
14, my lords.
But his cancellation took place in 2008 itself.
Cancellation took place, but after so many years, he again applied.
He only applied. He never got an allotment.
Lord,
he only applied.
For change of activity, my lords.
That's right, but that was never allowed.
My lords, as per the norms, my lords, for change of activity and for other any purpose, my lords, for that period since it was contravened, for that he has to pay the damage charges, my lords.
No,
my lords.
Read till clause 20. It is only upon cancellation.
In the event of cancellation of the allotment, the lessee shall be bound and liable to vacate, deliver to the lessor the vacate portion of the property free from all obstructions, failing which the lessee.
The rate is fixed in the lease deed itself.
Lease deed.
Now there's no escape. So it is fixed in the lease deed itself, my lords. All right. There's nothing in the matter, sir. The challenge in the present petition is to the imposition of damages by IDCO on the petitioner to the tune of rupees 1367,500 by virtue of a letter dated 2nd April 2015. The background facts are that the petitioner, a partnership firm,
it was initially a proprietorship firm,
which was initially a proprietary firm, applied on 17th December 2002 for lease of an industrial plot in the industrial estate Sambalpur. Full stop. The petitioner was allotted a shed in village Bare-Palian at a cost of rupees 390,950 by letter dated 2nd August 2003. Full stop. The shed was handed over to the petitioner on 29th April 2004. Full stop. According to the petitioner, it had applied for electricity connection and initially was allowed a single phase service connection by Wesco. Full stop. It is contended that 2 days after the connection was granted, after the 5 kW connection was granted on 16/10/2004, Wesco authorities disconnected the power supply, stating that there was a huge amount outstanding against the premises in the name of the previous lessee of the land. Full stop. It must be noticed at this stage that on allotment of the plot in favor of the petitioner, a lease deed was executed on 22nd January 2004. Clause 20 of which lease deed provides as under. So take from 1819, pages 1819, Annex 27 to the rejoinder. Paragraph. As far as the petitioner is concerned, it kept the shed unutilized and also defaulted in payment of statutory dues. Resulting in breach of the terms of allotment. First up, accordingly, a show cause notice dated 16/10/2006 was issued by IDCO to the petitioner. Stop. In reply to the show cause notice, by letter dated 27 December 2006, the SSC had admitted to not having started the unit open quotation due to some financial problem, unquote. On 26 September 2007, the petitioner was communicated by IDCO its decision to cancel the allotment, principally on the ground of non-utilization of the shed for the purpose for which it was allotted. Stop. The petitioner was asked to hand over possession of the shed free of encumbrances within 15 days. Paragraph. As regards the electricity connection, the petitioner was asked by the Executive Engineer Electrical Division, Sambalpur, to deposit rupees 140,828 with WESCO for the purposes of resumption of electricity connection. Paragraph. On 14 January 2009, IDCO issued another letter to the petitioner to deposit the outstanding dues and also hand over the plot allotted to it immediately. Stop. By the imputed letter dated 2nd April 2015, IDCO raised a demand against the petitioner, inter alia, towards damages to the tune of rupees 1367,500, apart from processing fee, provisional fee for allowing change of constitution of the unit, the annual ground rent, cess, annual IMC, etc. Full stop. While directing notice to issue the present petition on 2nd September, on 15 December 2015, this court directed the status quo shall be maintained. Stop. That interim order is continued since. Full stop. This court has heard the counsel for the parties. Full stop. It was not to be urged by counsel to the petitioner that the non-utilization of the shed by the petitioner was for bona fide reasons beyond its control. Full stop. It is submitted that without electricity connection, the petitioner could not have possibly utilized the shed, and therefore the claim for damages was unfair and unreasonable. Full stop. It is further submitted that it is only by a circular dated 24th October 2014 that IDCO fixed the rate of damages, and therefore there was no legal basis for it to collect damages when the lease deed was cancelled in 2008 itself. Paragraph. Counsel for IDCO, on the other hand, drew attention to clause 20 of the lease deed, which has been extracted here and before. So he submitted that once the allotment was cancelled, in terms of the above clause, the petitioner was required to pay damages, irrespective of whether it was unable to operate the unit for lack of electricity connection. Paragraph. The clause in the lease deed is very clear. Clause 20 of the lease deed is very clear that in the event of cancellation of the allotment, apart from delivering vacant possession of the plot to IDCO, the lessee would also have to pay damages at the rate of 500 rupees per day of unauthorized use and occupation. So, admittedly, despite cancellation of the lease, the petitioner did not hand over possession of the plot in question to IDCO. Stop. By virtue of the interim order passed by this court, till date, it continues to be an occupation of the plot. Stop. It is admittedly not utilized the shed in the plot, thus being in clear breach of the terms and conditions of the lease. Current terms and conditions of allotment. Full stop. Consequently, IDCO was justified in invoking clause 20 and demanding damages. Full stop. The reference by the petitioner to the circular dated 24 October 2014 is to no avail, since the rate of damages already stands incorporated in clause 20 of the lease deed itself. Stop. In other words, IDCO did not require to issue a circular as far as the petition is concerned, in order to raise a demand for damages. Stop. Paragraph. On merits, the petitioner has no valid explanation for non-utilization of the shed allotted to it. Full stop. The non-provision of electricity on account of the dues of the previous lessees was an independent cause of action, which did not provide any justification to the petitioner not to comply with the terms of the lease, terms of allotment. Consequently, the court is unable to find any ground to interfere with the impugned demand raised by IDCO. The petition is without merit and is dismissed. The interim order stands vacated.
Item 140.
None appears dismissed.
Item 144.
None of is dismissed. Interim order again.
Item number 145.
My lordship, we request for adjournment as we lost the file. The file is
Okay,
untraceable.
you revive it whenever you find it. Counsel, the appellant says the file has been lost. The appeal is dismissed for non-prosecution with liberty to revive it as and when the file is able to be traced.
Item 146.
146. 146 minutes. Yes.
Yes, sir.
146 minutes is the exception to my professional practice. It's a tax matter, minutes, entry tax matter. There, minutes, I formulated a point, but one point I've left there. Minutes already settled up that position. That audit submitted some report minutes that is within 7 days. That is under entry tax.
Correct. Correct. Correct.
Here in this case, minutes, my instruction is that point I've not formulated. Of course,
correct.
Instruction is that audit start report minutes, kind of a glass with that.
Only two questions have been framed, sir.
Two questions, that audit submission report and 7 days criteria, that particular point has not been framed. But anyway, minutes, I understand minors can visualize it. Minors settle of the law, and this is settled position of the law and law point. That is what minors, my humble submission.
Correct.
Audit started on 5/10/2012. And the audit visit report was submitted on issued on 11/1/2013. I have already deposited that amount. We have already deposited. What of 4 lakhs have been assessed? In fact, before the assessment made, we deposited the amount. Last minutes, 29/1/2013, we deposited the total amount, 6 lakhs amount, though it has been assessed 4 lakhs. Now only part is penalty. 2 lakhs penalty will be waived, then 2 lakhs I will get 3 lakhs.
Before any forum, my lord.
That exactly, I humbly submit that point of law. That was never
has been not been produced, and that has been checked out whether that was submitted.
With due humility,
within 7 days.
We can remand it to the tribunal.
My lord.
Tribunal will examine all this.
Well, so that they will examine that, my lords. In addition to another condition that whatever freight charges they have charged, that also they have not verified with reference to the documents.
That finding is there, my lord.
I have deposited that amount 6 lakhs amount.
All right.
Before that assessment started.
All right.
All
right.
So, my lord, penalty part is my lord has already decided 9C5.
42.5.
9C5, my lord.
9C5.
Yes,
OET. Correct.
So penalty part double the amount.
That's mandatory, sir.
That is mandatory. But what my lord says, here in this case only that assessment report, audit assessment report.
That's right. If you succeed in that, you succeed. If you don't, then penalty is automatic. You see, the present revision petition by the SSC arises from an order dated. Where is the tribunal's order?
Tribunal's order is at annexure. That is
order dated 23rd February 2016, passed by the
annexure 4
Orissa Sales Tax Tribunal Tribunal,
3.
Dismissing the SSC's SC number 129 ET of 2014-15 paragraph. While admitting this revision petition by the order dated 24th April 2017, the following questions were framed for consideration. Paragraph. Mr. Dayananda Mahapatra, learned counsel, the petitioner submits that although a question has not been urged or framed by this court, the SSC would like to urge the validity of the assessment as audit assessment under section, what is this, 9 capital C of the Orissa Entry Tax Act 1999 (OET Act). Since on account of the delay in submission of the audit visit report (AVR), Full stop. It is pointed out that the issue stands covered in favor of the SSC and against the department by the order dated 21st December 2022 of this court. Actually, it's that Chandrakanta Jayantilal, order dated 5th July 2022
My
of
lord,
this court
that
in
is-
STREV 69 of 2012, bracket State of Odisha versus Messrs. Chandrakanta Jayantilal Katak. And since it goes to the root of the matter, it ought to have been examined, even if it ought to be examined, even if it has not been formally raised by the SSC. Paragraph. The court finds that this indeed is an audit assessment under Section 9 capital C of the OET Act. And at the relevant point in time, the decision of this court was not available. Decision of the court in Messrs. Chandrakanta Jayantilal, bracket Supra, was not available, and therefore perhaps was not raised by the SSC. Full stop. That does not, however, mean that cannot be raised at a subsequent stage, since it is a jurisdictional issue. Paragraph. Since the tribunal also had no occasion to examine the issue, the court considers it appropriate to direct that the matter will, that the directors under 1, the impugn order of the tribunal dated December February 2016 in essay number 129 bracket ET of 2014-15 is set aside, and essay 129 bracket ET of 2014-15 is restored to the file of the tribunal for a fresh decision. 2, among other issues to be examined by the tribunal in terms of the memorandum of appeal filed by the petitioner, it will also examine whether the audit assessment is invalid on account of the delay in submission of the AVR in terms of Section 9 capital C bracket 5 of the OET Act, and in light of the decision of this court in Messrs. Chandrakanta Jayantilal Katak bracket Supra question mark. Sorry, full stop. 3, the court clarifies it is not expressed any view in the matter. 4, the tribunal will also re-examine the issue concerning freight charges after examining the vouchers produced by the petitioner, forming part of the record. Paragraph. The above appeal will be listed before the tribunal on 1st March 2023, on which date the petitioner will appear through an authorized representative. The tribunal is requested to proceed with the appeal and dispose it off in accordance with law after hearing the parties, preferably within a period of 6 months thereafter. The revision petition is accordingly disposed.
Right, with your lordship's leave, my lord, 144 item is not called out. Correct?
Yes, yes.
144.
Tell us.
Yes.
144.
144, my lord. Yes. You must have a limited grievance. I purchased a piece of land from the recorded tenant, and subsequently the authorities, they accepted rent from me. But over the years, my lords, the land appears to be recorded in the government khata, right? Certain specific orders passed by the revenue authorities. Now, I filed an application before the authorities in the RTI Act. They say no such orders have been passed. If I take your lordships, that is an Odia vernacular. I'm sorry, my lords, I couldn't replace it with the English translation. Page 36. Your lordships brief, it says, by order dated 28/12/2010, and 13 January 2011, passed by Tahsildar and the collector respectively of the district Dhankanal Milas. So this land has been recorded in the government khata as per the record of right. Then I applied before the authorities under Annexure 4, page 37 of your Lordship's brief. What are those orders so that I can either approach the authorities in appropriate forum? They say that in such case, no such orders have been passed. My grievance is I have purchased the land by Annexure 2 through a registered sale deed from the recorded tenant who is declared to be a tenant under the state by Annexure 1. And my mutation case is pending before the authorities. They are not doing it.
Yes, who's for the state? Who's appearing, sir? Nobody for the state in this matter?
He has just gone. Mr. Mohanty has.
All right, you wait, sir.
Yes.
We'll wait.
Or your Lordship may call it on Monday.
Not calling it in the weekly list. Stay.
Yes.
Let's you wait for some time.
Yes, I'm ready.
Item 147.
147, may I pray for next week, my lord? The arguing counsel is with an unbilled day.
Whom are you for, sir?
I'm for the respondent, my lord.
One minute. Let's see who's for the state.
All are of states revisions, my lord. I request my lords to take up sales tax revision number 26 of 2017. The question of law is that page 11 of the revision petition, my lord. Question number A, whether in the facts and in the circumstances of the case, Kinley water sold by the opposite party company falls within the scope of entry 4 of taxable list. Whether on the facts and in the circumstances of the case, the Odisha Sales Tax Tribunal was not justified in ignoring to take into account the material placed before it by the revenue to show that the opposite party.
Question AB is already covered, I think, in dealer's appeal.
My lord, I only saw one document from this record. That is that page.
Can we go into again? In the dealer's STREV, in respect of this.
My lord.
This Kinley water has been decided, I think.
Yes.
That part is over.
Yes. Then, my lord, question number C.
No, only one question has been framed. 2nd November order. Just see the 2nd November order. Only one question has been framed.
That was there, my lord. But
yeah, we'll show you the paper book.
He was collected 12% tax and is paid to the exchequer 4%. That is the.
It's already answered in favor of the assessee, sir. What does entry 4 say? This is OVAT, is it? Or OET?
My lord, only one question has been.
Only one question. OST. Such a
Well, that is the page 6 of my revision petition. I have called out that entry.
No, here also I think that is covered. That STRE was.
My lord, I just.
May I please, your lordship, that Inlay issue is still on, your lordship. It's not settled. That packaged drinking water or the mineral water, that issue is still on because that question now is open here.
Left open.
Yes, yes, it's there.
Where is the entry for? I don't know. Where have you reproduced the entry?
It's
You've reproduced the entry.
Page 6, I have called out that entry, my lord.
Let's see.
Tax free. The next page, water, but not aerated water or mineral water sold in bottles or sealed containers. And taxable list is aerated or mineral water sold in bottles or in sealed containers. Here, my lord, I would like to show only one document, my lord. That is annexure. I have annexed page 47, annexure 4, my lord. The DIC certificate by the Coca-Cola company, my lord.
Aerated water, correct.
Manufactured in the original unit undertaking EMD, aerated water. That has not been answered by the tribunal.
Oh, I see. What does the tribunal say? Let's see.
Tribunal has on page 43, my lord, finding of the tribunal.
Page 37, just see 37. Middle. Learned counsel on behalf of the dealer submitted that ACST is erred in resorting to surmises and conjectures.
My lord. That is his submission, my lord.
No, just read. Let's read it.
Para 16, my lord. The law
15. Middle of 15.
For the assessment year 2003 and 4, the Law and Council appearing on behalf
middle of it, sir. Come to the middle. The allegation that the learned counsel on behalf of the dealer submitted by that ACST is erred in resorting to surmises. You got that? Middle of the paragraph.
My lord. Now the allegation that Kinley water is known as mineral water. In common parlance is totally unsubstantiated, especially in view of the fact that statutory, the name of the content is clearly mentioned as packaged drinking water or mineral water. As the case may be, on the labels affixed to the package, which leaves no scope for doubt in the mind of the consumer as to the precise nature of water that they are purchasing. Packaged drinking water and mineral water can also be clearly distinguished from the fact that mineral water typically commands a substantial price premium as compared to packaged drinking water. That is his submission, my lord. And the finding is at page 43, para 27. Coming to the dispute relating to disallowance of the sale of packaged drinking water in the brand name Kinley from the exempt turnover and taxing the same at the rate 12%. In the present case, the appellant during the assessment years 2001, 2, 2, 3, 3, 4, and 4, 5 inadvertently paid tax on the sale Kinley water under a bona fide mistake of law. But the moment come to knowledge of the appellant that entry number 39 is there in the rate chart under Orissa sales tax laws, he filed revised return adhering to the provisions available under the Orissa Sales Tax Act. There is catena of decisions where delayed filing of revised returns, then the next para, my lord. Entry seal number 4 of list C, aerated or mineral water sold in bottles or in sealed containers. It speaks that only the specially treated water, either by addition of specific gas or specific mineral, when sold in bottles or sealed containers, comes under this entry and taxable at the rate 12%. Under the Orissa Sales Tax Act, it is clearly from the contention of the dealer company is that para 3.2 Indian standard on packaged drinking water other than packaged natural mineral waters, specification at para A32 and A33 of the prevention of food adulteration rules can be appreciated with regard to submission of the dealer, and it will be suffice to say that on the basis of standard prescribed by the Bureau of Indian Standard and Prevention of Food Adulteration Act and rules, Kinley water in the packaged drinking water coming under exempted list under Orissa Sales Tax Act. My humble submission before my lords.
No, actually, the way of reading that entry itself is wrong. Because what is only exempt, what goes out is aerated mineral water sold in bottle or seal containers.
My lord.
The minute it is sold in water, bottle or seal containers, it goes outside the purview. This entry 39 of list A,
my lord,
is
water but not aerated water. Aerated or mineral water sold in bottle or sealed containers.
What is that list A? Where do you get it?
Page 7, my lord.
Is this packaged mineral water? Yes. What the state is agitating, but here, your lordship, so we are manufacturing of this packaged drinking water, although they are categorically telling it's a mineral water. The purpose of it, it's because when there is an ambiguity by a person,
the word drinking is not used either in entry 39.
Only water. Under 39, your lordship, is water. Water includes drinking water, your lordship.
No, but that's okay. It may include drinking water, but you are having water which is packaged.
Wow.
So in the selling water, water but not aerated or mineral water sold in bottles of sealed containers. This 13.
But I think your label on the bottle itself shows that
what is exempt is only plain water. The minute it is aerated or mineral water sold in bottles or sealed containers, it gets out of exemption.
Your lordship, in our case, it's not at all coming under the category aerated or minerals, because we are manufacturing under the Bureau of Indian Standard as well as the FSSAI. It's a statutory body, and that is categorically defined what is the mineral water, your lordship. Your lordship, kindly have a glance to this food safety FSSAI, Bureau of Indian Standard.
No, but he was referring to,
your lordship.
Which page did you refer to? That,
my lord, that is the DIC certificate at page 47.
47.
So earlier, while setting up the industry, because apart from this, your lordship, packaged drinking water, we are also manufacturing of aerated water.
This is of the year 2011.
Prior to this.
Your assessment is much earlier to this.
Our assessment is much earlier, your lordship.
Yes.
But so far as the DIC the certificate of registration, what my lord is showing to lordship. So DIC has given us the certificate for aerated water. We are manufacturing aerated water. That we are not disputing. But here is skilled water is falling within the category of drinking water, because apart from drinking water, your lordship, we are also manufacturing of aerated waters. But aerated water is falling under different category. We are not
mineral water.
This mineral water means the mineral water is not defined out of this statute, your lordship. So ultimately, this mineral water governed under the Bureau of Indian Standard as well as FSSAI. And there it has been clear, we are being categorized as the packaged drinking water. Because so ultimately, under the common parlance, in somebody is going to and ask for a water, its objective is to get a drinking water. So, which is free from any contamination or usable of a drinking water. His object is not to ask for mineral water. Mineral water, it's clearly defined under this Bureau of Indian Standard, Your Lordship. It's page 409, para 2.10.7. It's mineral water has been defined, Your Lordship.
May I, with your Lordship's kind permission?
Where is it?
Yes, page 409 of that. Yes, 2.10.7 mineral water.
Correct.
Distilled water.
So, Your Lordship, this mineral water means include all kinds of mineral water or natural mineral water by whatever norm it is called and sold. So there are different elements and which has been categorized as mineral water.
No, is yours a mineral water?
Not at all, Your Lordship. It's packaged drinking water.
My Lord.
Yeah, 48 you have said aerated, but it can't be aerated.
How skilled water is aerated?
Well, about the label that assessing authority has giving is finding.
Aerated water is soda water.
Your Lord.
This water selling is not soda water.
My Lord, I'm just showing page 17 of the assessment order, my Lord. The finding is there. Packaged drinking water, ingredients, treated water, minerals, sodium, chloride, magnesium, sulfate, manufactured by HMJL Beverages Private Limited, plot number 7, phase 3. IDA.
So it does contain minerals, but is it?
My Lord, the label itself shows. The label itself shows from the wrapper itself. It is evident that the ingredients of the products are treated water, minerals, sodium chloride, magnesium sulfate. So the water sold by the dealer is nothing but water mixed with dissolved common salt and.
So this is the package on the Kinley.
My Lord. That is the finding of the assessment.
So we have to add up, in absence of the definition of mineral water under the statute, we have to go by common parlance. So under common parlance, Your Lordship.
What is mineral water in common parlance? You tell us.
So
no, the question is then you have to ask what is mineral water in common parlance?
So there has to be a substantial element of mineral content on the water.
Oh, where do you get on?
So under this FSSAI guidelines,
this is a guideline which came in 2011.
Yes, Your Lordship.
Even if you go by this guideline, just read the guideline carefully.
Mineral water, Your Lordship, I can place. Mineral water means includes all kinds of mineral water.
You stop here. Once it says all kinds of mineral water, water with any kind of mineral will be mineral water. It's supposed to be as wide as possible, which is why they use the word both means and includes. So, by whatever name it is called and sold. So you squarely fall within that.
Then in para 2, description and types of mineral.
That's different. That's further. Then one states natural mineral water.
Your Lordship.
This common parlance, my lords, interpretation was long ago taken care of by Justice Hansaria and Justice R.K. Patra in Bindley's Chemicals. When I was appearing before the Honorable Chief Justice Hansaria, and he said that when you go to the shop, ask for water, then they will give you this mineral water.
Correct.
And therefore, in the court itself, he rejected my petition. I challenged it, reopening of the assessment on the ground that this
AG objection.
AG objection on which this reopening, I said that this water is different, packaged water, and it is water only. Then he said that no. That common parlance was very much, Chief Justice Hansaria didn't appreciate it. And unfortunate on my part, it was rejected.
Your Lordship, the objective is to ask for a drink for the purpose of drinking. Not my intention is to, unless something contains minerals.
No, you won't buy. Why should you pay 10 rupees for a bottle which contains plain water?
Because it's free from contamination. It is a free from contamination.
The attraction is it is mineral water. In fact, they say it's rich in minerals from Himalaya, original source.
Yes. So that's the overhead cost.
Yeah.
Your Lordship, actually this arguing counsel from Delhi is ill. So let it come in the next week itself. Let it stay on board. Your Lordship, my humble request.
Why suddenly?
No, actually, originally, that's why my associate was asking for time, because actually the arguing counsel from Delhi is real. I just got a message that's why I want to pass. So let it be my respected person. So
it will stay on board. All right. Monday it might come up on Monday then.
Your Lordship, highly obliged.
All right.
May I please? File or
You have the
let our
records.
name be uploaded
You
in the
have the
list.
records, assessment records.
My lord.
You have the records. Original records you have.
No, my lord.
You keep the original record. You keep the original record next time. These labels and all that.
Okay.
Get hold of the label.
Then, my lord, it takes some time, my lord.
No. Get it now. If you go to the shop right now, you'll pick up 2 Kinley bottles.
Your lordship,
at that point of time.
At that point, yes, at that point of time, what was the seal? So that has to be seen. Obliged.
Hopefully, we're not drinking Kinley water. Then we have to recuse.
It was only in the yesterday event, Milan. Whereas why I remember this Bindley's chemicals case.
Yes.
On that day, I had a temperature of 103 degrees.
I see.
And Justice Hansaria didn't allow time. So I have to stand up and argue for 1 hour.
Okay.
And my opponent was none other than Justice Patnaik, Anand Patnaik, who later on was elevated to.
Yeah.
And I was at that time very junior matters. I had 7 years of experience in the bar.
87.
Bigger part?
It is perhaps in 87.
No, it is 92. 87, Justice Hansaria didn't join. Hansaria came in February 1990.
I see.
As the Chief Justice. Now, in my case, what has happened, matters. Item 147, STRB 37 of 2017.
148.
148, my lords. I'm sorry, extreme sorry. The period is, my lords. Here, my lords, you will kindly see, no notice for audit visit was given by the audit party, that is annexed 2, and audit report was submitted. Now I take your lordships to the tribunal order page, how the tribunal has dealt with this. I will take your lordships. 80, sorry, my lords. Just
starts at page 80.
Yes. এটা কোড আর কোন দউছন এটা 37 yes 80 yes we have heard 83 we have heard learned additional standing counsel for the revenue, learned counsel for the dealer carefully considered the contention and grounds taken in the appeal memo as well as written submission filed by the appellant dealer and the materials available in record. We are of the considered view the dealer has tried to twist the fact in his favor by misinterpreting the provision, that is submission of AVR report within completion of audit, not within the date of visit of audit visit under section 41 bracketed 4 of the OVR Act. Similarly, under section 42, subsection 2 envisages that where a notice is issued to a dealer under subsection 1, he shall be allowed time for a period of not less than 30 days for production of relevant books of accounts. It applies from the date of issue of notice because not known when it will be served to the dealer in order to provide reasonable opportunity to prepare. Malice, nowhere that I was served with a notice for audit has been established. I have taken the same ground in my revision application, that is 1.5 malers. $1.5 million. I have taken this that and much prior to, after the filing of the revised payment of the tax. Yes. And another thing, my lords, the audit period is the report your lordship will see is for the period 1/4/2007 to 31st of March 2008, and your lordship will see the assessment order at page 66.
1/11/2007.
Yes.
30 September 2007.
Yes.
And this also has not been dealt with by the tribunal.
Yes, that has not been dealt.
But notice has been served with the AVR, that is page 67.
Yes, but you have not given the notice under Rule 42. Where is your notice? And much prior to it, in 2008, I have filed the revised returns when I came to know that, yes, there is some mistake in the, I have paid by the Annexer 3A is the tax I have paid. That is the whole thing, my lords.
These were never before the lower forums. These questions were never before the lower forums.
It was there before the tribunal. Dear Standing Council, please see.
Grounds you have not attached, I think.
But the first point A, 7 days.
Yes.
Is that not enough for you?
Page 81.
Yes.
Para 3.
A.
81.
That is his submission.
And
that
C,
is his draft.
no notice for audit visit was issued.
Was issued to the appellant.
Yes. Point C is the no notice.
It has to be verified.
Then stay on board. You better get the records now. For all
Yes.
the original record you must have.
Yes. That will be.
Need some time, my lord.
Anyway, you write to them. It's only Wednesday now, Thursday.
1 week
Stay
after,
on
my
board.
lord. 1 week after, my lord.
You'll stay on board. You write to them immediately.
My lord.
Right.
149.
That's covered, my lords. That is that penal interest under section rule 8A3. And the question has also been admitted on that ground alone. And your lordship have kind judgment kind. Good.
CSTO
is covered by your lordship judgment.
Again.
Eta Xerox in eta no. HTRV. Eta. General Traders the Parampur. Yes.
No, Duro Pay is interest paying. Interest paying.
Interest. Yes. Penal interest.
Penal interest has not been admitted.
No.
Only question is whether interest.
penal interest.
My lord.
Interest.
Not penalty.
Our question of law ta kodala. Question of law which was admitted. It says that
under Rule 8A1 of
yes.
CSTO rules.
Yes. 8A1. Directed that the operation of levy of penalty at the rate of 2% under Rule 8A1 of the CSTO Orissa rules shall remain in abeyance till the next date. It is made clear. The question is whether in the facts and circumstances of the case, the penal interest at the rate of 2% under Rule 8A1 of the CST Orissa rules could be levied simultaneously while levying interest at the rate of 1% under Rule 8.1 of the CST Orissa rules. That is the question which has been admitted on 14th of July 2017. So that's not the point.
So there must be first a failure to pay the interest, and only when this failure to pay interest, penal interest will come.
Yes.
Can't be simultaneous.
Yeah, it cannot be simultaneous. And there must be some contumacious conduct.
This has to be answered in favor of the assessee, sir.
My lord. The commissioner notification is also there not to impose penalty.
All right. The present revision petition by the dealer arises out of an order dated
Thanks to the Standing Council.
31st March 2017, passed by the Orissa Sales Tax Tribunal. In the assessee's appeal, in the dealer's appeal, being essay number 76 bracket C of 2015-16 for the tax period 1st April 2007 to 31st March 2012. Paragraph, while admitting this revision petition on 14 July 2017, the following question was framed. Paragraph. A perusal of section 8A bracket 1 of the CST bracket O bracket rules 1957 reveals that the penal interest payable thereunder at rate of 2% per month is open quotation on the tax and interest so payable, unquote. Stop. Rule 8A bracket 1 is titled open quotation levy of penalty for default of payment of tax and interest payable, unquote. And it reads as under reproduce 8A1. It is plain, therefore, that the penal interest at 2% under Rule 8A bracket 1 would become payable only where there's a default in payment of the tax as well as interest, as envisaged in Rule 8 bracket 1 of the CST bracket O rules 1957. Full stop. Sequentially, therefore, it is only when a dealer fails to pay interest under Rule 8 bracket 1 will he become liable to pay the penal interest under Rule 8 capital A bracket 1. In that view of the matter, the question of simultaneously raising a demand for both interest and penal interest at the same time does not arise. Paragraph. Consequently, the question is answered in the negative, that is in favor of the SC and against the department. And it is held that penal interest at 2% under Rule 8 capital A bracket 1 of the CST O rules 1957 cannot be levied simultaneously with the demand for interest at 1% under Rule 8 bracket 1 of the CST O rules 1957. Paragraph. The impugned order of the tribunal and the corresponding orders of the first appellate authority and the assessing officer to the above extent are hereby set aside. The revision petition is disposed of.
With your lordship's kind permission, I beg to mention that I've got another item 159. Let it be on board.
Yes, yes.
And I have skipped dinner yesterday. And I have skipped breakfast today and also lunch.
Oh my goodness. Okay.
Much obliged, madam.
Is he there? 140? Who is that?
Item 144.
My lord.
Even now he's not.
Auntie was 144.
You may not be allotted with this case.
144, my lord.
But none is there.
Let it come tomorrow. I will inform Mr. Mohanty. All right.
Your lordship may accommodate me only for tomorrow 24 hours. Your lordship
Anyway,
may call it
tomorrow we
Monday.
won't take it up. Tomorrow
Your
Friday.
lordship may call it Monday.
Tomorrow anyway we won't take it up. Only on Monday now.
I'm grateful.
Obliged.